Greetings to everyone. I, Nida Ghaffar, along with my co-host Adrit, warmly welcomes you all to Technical Session 2 of the South Asian Conference on Constitutionalism and Democratic Governance 2026. This conference is being organized under the South Asian Academic Summit 2026 by the Center for Development of Intellectual Property and Research, Naovina Development of Intellectual Property and Research Foundation in collaboration with the International Institute for Democracy and Electoral Assistance and the International Society for Public Law. This conference is not only an academic dialogue but also a vital platform for advancing constitutional values, democratic governance, and institutional accountability in South Asia in the global south. It focuses on addressing contemporary challenges such as constitutional backsliding, judicial independence, electoral integrity, digital governance, and protection of fundamental rights, while fostering comparative and policy oriented scholarship. Through this conference, we aim to strengthen democratic institutions and amplify South Asian voices in the global constitutional discourse. Now, introducing the organizers. The Center for Development of Intellectual Property and Research, CDIPR, is a premier institution established as India's first non governmental research organization dedicated to intellectual property rights. Operating under the Naovina Development of Intellectual Property and Research Foundation as a registered non governmental organization. CDIPR is dedicated to promoting and protecting intellectual property rights within India, thereby fostering a conducive environment for innovation and creativity. We are a community connecting 2,200 plus members and 12,300 plus global academicians on intellectual property rights. Our collaborating partner, the International Institute for Democracy and Electoral Assistance, IDEA, is an intergovernmental organization that supports sustainable democratic institutions worldwide. IDEA works to strengthen electoral processes, political participation, constitutional design, and democratic accountability across diverse regions and the International Society for Public Law, ICONS, is a global scholarly association dedicated to advancing research and dialogue in public law, constitutional law, and comparative governance. ICONS connects academicians, practitioners, and policymakers to promote excellence in public law scholarship. We sincerely thank IDEA and ICONS for their invaluable intellectual and institutional support in making this conference a success. Next, I'm honored to introduce our session chair for today, Mr. D.S. Mandal, Executive Member of the Center for Development of Intellectual Property and Research. We are grateful to you for kindly agreeing to guide today's session.
Thank you, host. Am I audible?
Before we begin, I would briefly outline the. Yes, sir.
Okay.
Okay, sir.
Am I audible?
Good evening, everyone.
Hello.
Yes, you are audible.
Okay, you can continue.
Good evening, everyone. Before we begin, I would like to briefly outline the presentation. Each presenter will be given a 5-minute and 1 minute for questions. And I take this opportunity to welcome all our presenters, thank them for contributing their valuable research to this conference. I now invite our first presenter, Nanda Das from Tata Institute of Social Sciences. May I request you to kindly begin your presentation?
Thank you so much, host. I'm going to present right now. Yes. So, very good evening to all of you. I am Shunanda Dash. I am doing PhD from Tata Institute of Social Sciences, Hyderabad, and my today's presentation topic is role of civil society and media in democratic defense. So now moving towards my next slide, and my next slide is about agenda. So what is my today's agenda? In which some matter today I will raise my voice in front of eminent judges and eminent scholars. My today's agenda is about introduction. Briefly, I will try to introduce what is civil society, what are the role of judiciary, and why we need to raise our voice. And next is primary goals. Without goals, it is not possible to bring any research. So it is very important. Areas of growth, how much we are competent enough to reach towards the goal, timeline and summary. Next, moving towards next slide, and my next slide is about introduction. So here in this portion, I will try to look after on some interesting issues, and that is self-governing protection without civil society. So, what is the meaning of civil society? Civil society meanings where citizens and common interests are matter and collective activities are matter. Without common interest and without collective activity, it is not possible to reshape a civil society. The meaning of collective activity. What is the meaning of collective activity? The meaning of collective activity is that working together, such as Narmada Bachao movement, Chipko movement, Dalit atrocities and movements we all know about. So this is, and here we will look after on this self-governing, that means if and protection. This is very important. Civil society and media work together to shape honesty and risk ingesting. To protect subdivision, civil society and media do play important role, and NATO alliances, NATO alliance countries. What is the meaning of NATO alliance countries? The North Atlantic Treaty Organization, this is NATO, a political and military alliance of 32 countries from North America to Europe. What are the fundamental goals of NATO alliance countries? The fundamental goals of NATO alliance countries are that to safeguard freedom and security, and also promoting democratic value, promoting human rights, promoting democratic rights. This is, and for to make all those things, self-governing protection, civil society, media work together with honesty and protect subdivision, and civil society and media do play an important role. Moving towards next slide. My next slide is about primary goals. So what are the major objectives of my today's research? Major objectives are to find out the roles of civil society. I mentioned earlier the civil society meaning where citizens with common interest work together. For what reason they work together? They work together to safety plans and to reduce risk and dishonesty. If we can see that that anytime corruption can happen, to stop these kinds of corruption, to raise the voice against all kinds of corruptions, it is very important to reduce dishonesty. And in very, if we see highly industrial sectors where industrial law are present, we can see the persons who work they are highly efficient. They do follow all sharp lines of bureaucracy, and they do follow all kinds of bureaucratic rules and regulations. So chances of dishonesty are very rare there, but dishonesty is present in the grassroots levels. So to reduce all those things, civil society work to promote safety plans. Now, second objectives is that CSOS container equilibrium and asset in honesty. So why we talk about asset in honesty? We talk about to bring equilibrium in our society. If you see, if you look after on grassroots levels, then you will find out it that within grassroots levels there are equality, there are imbalance between equality and equity. So to promote equilibrium, to make inclusionary development, it is very important. Efficiency with protection subdivisions. In our society, efficient labors are very important. Efficient judges are very important to protect the subdivision, to protect the rights of common civil masses. For that reason, I have mentioned earlier about Narmada Bachao movement, Chipko movement. This movement, it is a kind of resistance. And what is the resolution of that? To bring the rights of common masses. Common masses, they fight for their rights. They fight for the rights of water. They fight for the rights of land. They fight for the rights of their identity. So efficiency within protection and subdivision, this is very important. And when we talk about Tebhaga movement, when we talk about water protection movement, biodiversity movement, these movements are for what? To protect the rights of civil common masses. So that is now role of civil society and media democratic defense. So if we see the data, then we find out that participatory budgeting, social media, e-voting, e-governance, blockchain, geospatial technology, crowdfunding, these all are present in this diagram. And here, what is the impact of social media? Because nowadays, in this 21st century, it is not impossible to get to know
Participant, already
anything.
you are exceeding time. Already you are
Okay.
exceeding time. You can conclude.
Okay, so it is not impossible to get to know about this matter. Now moving towards next slide, areas of growth. What is that? Watchdog functions, information and education, advocacy, inclusivity, conflict resolution. Antonio Gramsci viewed civil society as the crucial arena for manufacturing consent and establishing cultural hegemony rather than just a private sphere. Key areas of growth, that is digital rights and cyber security, strategic litigating and legal defense, countering transnational representation, environmental justice, climate action, protection and electoral integrity. Now summary. Lastly, summary, and that is we have to find out watchdog function, catalyst for social change, bridge between citizen and state, conflict resolution, restricted civic space, financial vulnerabilities, digital surveillance, and harassment, quote unquote harassment. Now, future outlook and strategic directions. What could be movement mindset, technological adoptions, domestic funding and diversification, international solidarity, quote unquote. Now, these all are my references. From Braun, Hans, Will, Adams 2, and Nichols Mason. I have used 7 references for that, and thank you so much for your patient listening. Thank you. Should I stop share?
Yeah, I have a question for you. Can democracy endure without a free and critical media?
Can you kindly repeat? I just stopped my share. Yes, please repeat, sir.
Can democracy endure without a free and critical media?
I cannot hear. Sorry, because of bandwidth problem. Can you kindly repeat, please? Can demography
Endure without a free and critical media?
Yes, it is. Critical media you are talking about it. It has its positive and negative aspects too, and we cannot assure you that with the help of media, we all the time will be competent enough to enlarge democracy in our society. So there are loopholes within that. There are some critical aspects within that. It is not possible all the time. That's it.
Thank you very much.
Thank you so much.
Thank you. Our next presenter is Sakshi Pandey with the co-participant Unna and researcher in law. You may now proceed.
Good afternoon. Am I audible? Good afternoon, everyone.
Yes, Unnap, you are audible.
Yeah.
Okay. So the today's presentation is in this today's presentation, I will be examining how traditional equality frameworks, especially in India, fails to address the lived realities of people who experience different kind of discrimination, not on just one ground, more than one ground at the same time. Today, the focus is on intersectionality and where single access
Participant,
equality.
participant, have you already presented your paper? on technical session
Yes,
1?
yes, yes. I have presented my paper in morning also, but my presentation was scheduled in second time also.
Okay, so it can be some technical issue like regarding clerical error. So you
Okay,
need not to
okay,
present now. Already your marks are entered. So we can move
okay,
ahead with the
okay,
next
sir.
part. All right, yeah. Host, we
Okay,
can move
thank you,
ahead
sir.
with the next part.
ठीक.
Our next participant is Sairaj Gaur from Center for Research and Planning, Supreme Court of India. Sairaj, you can start now.
Hi, I'm just trying to present. One second.
You are not a
Uh,
visible participant.
yeah, I'm turning on my camera, sir. The camera, there was an issue. Hello, can you see me
Yes,
clearly?
yes. Kindly present
Yeah,
your presentation. Yeah.
yes, sir. I'm just uploading the presentation because I was been trying to do that for 2 minutes now.
Yeah, like it's a note to all the participants. Kindly keep your presentation loaded. It takes time.
Yes, sir.
Prior to your slots, it keep your presentation loaded. Yeah.
Presentation is loaded, so there was just an error from my MS Office. Apologies. It's just processing right now. It's being uploaded. Can the organizers just tell me if they can see the presentation, if it's been uploaded?
It's not yet visible.
Yeah, is it visible now, sir?
Yes, you can start.
Yeah. I am setting my own timer, sir, just so that I don't miss out on the 5 minutes. 1 second. Yeah, I'll just start in 3, 2, 1. Good morning to everyone present here. Good afternoon. I'm sorry. I'm Sairaj from the Center for Research and Planning at the Supreme Court of India. I work there as a judicial law clerk and research associate. I'm going to be speaking today specifically about the judicial implications and generally a case comment on the Gulfi Fatima versus State NCT of Delhi case, which in other terms can be termed as the Umar Khalid and Sarjil Imam bail case. Extremely popular in recent times, and especially in the last 2 years, where there's been a lot of media involvement. What exactly has this media involvement been? And this particular case, or this particular paper that I have written for this journal, is called Liberty by Distinction, which deals with selectivity that the Supreme Court of India and the two judges have shown with selective interpretation, the selective bails that they've given to 5 individuals but not to two, and lastly the selective judicial leaps that they've taken. So the theme generally is selectivity, on which I lie. Secondly, on how exactly are we going about in this paper, right? First one, I'm going to introduce to you how the court itself frames the entire logic of their judgment, how they frame the landscape, and how from there, that point itself, we understand that selectivity is going to be a theme. Then I'll go into selective bail that they've given, which is the main point that the media is talking about. Then I will go after that into selective interpretation that the court has done, not only of statute but also of judgments. And then we will speak about selective judicial leaps that the court takes to a certain extent to justify its own stance, in some sense calling it the mental gymnastics of the Supreme Court of India, or probably a reverse construction from an outcome that was pre-decided. And lastly, while concluding, I'll go into the implications of this case and why this case is extremely important as a precedent in future UAPA cases. Now, what exactly is the introduction to this? How does the court frame the stakes here? In the first one that you see, paragraph 13, the court specifically talks about the facts of this case. It says the Delhi riots, 54 people died, especially and among them is a senior police officer and an intelligence bureau official. The number of people that died is 54, yes, but a majority of them, more than 45, were poor Muslim individuals who lived in these poor neighborhoods of Jasola or Okhla, in one of those ghettos where the Northeast Delhi riots really happened. They took most of the brunt of these riots, but the court very specifically plays a very subtle game of foreshadowing, where it talks about the senior police official and the intelligence bureau official who have died, while not making any notice of the other people who have died. They towards the end just say, as well as grievous injuries to several police personnel and civilians. Civilians find themselves in the end. Who are these civilians? What is the demography of these civilians? We don't really know about, because the Supreme Court does not want to go into that. Secondly, in terms of how it frames the stakes on what exactly it is doing here, why is this case important? According to it, it says that this court is not engaged in any abstract comparison between the constitution and a statute, the statute being UAPA. It says the question is more precise. In prosecutions under the UAPA, when delay and prolonged incarceration are invoked as a ground for bail, what is the principled approach that a constitutional court which shall take for such a plea? Having set this as the ground, what exactly does the court do? It gives selective bail to all individuals within this case except to Umar Khalid and Sarjil Imam. Why? Because within the common FIR, it says that there is a distinction to be made. The common FIR says all of these people are guilty for causing riots of the February 2020 Delhi riots, because they were part of the same WhatsApp groups. They went to the same meetings that were either public or private, and they therefore conspired for violence to take place in Delhi. But while they come from the same FIR, the court makes a distinction and says Sarjil and Umar were the ones who should be given special status because they were admins of the group, or they were the first ones to be speaking at public speeches, and thereby they were considered leaders, and that's why they must be considered as masterminds. The court plays in some sense a double game with itself, which could also be called which could also be called its own mental gymnastics. Lastly, it's in direct contravention. This selective bail that they've given is in contravention with another landmark case called Arup Bhuyan versus the state of Assam, where there is a distinction made between advocacy and incitement of a particular riot or a commotion that takes place in public. Secondly, what is selective interpretation that the court does? This paper looks at how the court in this case, in paragraph 48, says that at this stage, it selectively interprets. It says the court does not weigh evidence, test defenses, or conduct a mini trial. But in any case, it says whether the prosecution material taken at its highest, I think the taken at its highest must be taken must be looked at very carefully, because it says it's not going to weigh evidence, but it's going to take prosecution material at its highest. That means the Delhi police in its charge sheet, which was 5,000 pages, could say anything about any of these individuals, but anything that it says will be taken at its highest, while the court says it will not weigh evidences. That means there is a very open double speak, again, a very open selective interpretation the court is doing, something that's being done openly, but very rarely is looked at very critically by anybody who is studying law or is in critical studies in the law. So that is a selective interpretation they do. I'd just like 30 more seconds to conclude this presentation. Lastly, I would like to speak about selective judicial leaps. The last thing the paper discusses is the selective judicial leaps. Here it says, delay was the main point of this entire UAPA. This thing, Omar Khalid being in jail for 5 years was a massive media thing, and thereby anybody can't be kept even for serious crimes for this long without trial starting as an under trial. So the court answers that question by saying, first, delay may be of such magnitude and character that continued detention becomes per se unconstitutional, irrespective of the strength of prosecution, say. And second, it says delay may be pressed as a circumstance to contend that statutory satisfaction under section 43d5 stands diluted. It says one and the second, and then immediately says that the present case on an examination of the record does not meet this threshold. Here we see that the court makes an extreme judicial leap by telling us very much that it's not okay for somebody to be in jail for this long, and then says secondly that the constitutional and statutory threshold that is there, this case does not meet, even if it's extremely famous in the media for having met that threshold. So it's a judicial leap that it takes, and the paper goes in little more detail about that. And finally, to conclude this, what are the implications of this particular judgment? It becomes a precedent in every single UAPA bail case that might come up, that the ED or the CBI might pick up anybody on a UAPA charge and put them in jail, and their bail might be denied in the future by a high court or a district court or even the Supreme Court, citing this particular case as an example on why it should be denied and using the reasoning that this particular case uses. And specifically, it becomes a massive judicial adjudication on all political protests that might take place in the future. It disincentivizes anybody from involving themselves in non-violent political protest, whether it's against the state government or the central government, under the fear that the UAPA might be slapped on them. And the section 43D interpretation that this court has taken in this judgment will be applied to anybody who might want to protest in a country that was born in opposition to the British Empire after years of protesting non-violently. That, I think, is the conclusion of my entire thing. Despite what the court has said in this, hope still lives on, because those two who have not been granted bail and still are in their particular cells at Tihar jail right now have not lost that hope, have continued to go on, and they will take on this fight judicially. perhaps the answer to this particular judgment is in the future some other judgment of a higher strength of bench, maybe a constitutional bench, that will strike this down and show us there is a way of non-violent political protest within this country, and that can be achieved through non-violent ways in the future. Thank you very much.
Okay, participant, you had mentioned that selectivism in Supreme Court has very well nowadays. It's one of the part and parcel of various judgments. So when we also prepared a report in some of the governmental and intergovernmental organizations regarding the reformative judiciary, we also take those in consideration. Now, my one important question towards this: so when we consider that in judiciary there are various selective cases, and the and the outcome of those cases are also very selective, like there are 2 3 probable ways the cases can be solved, but the judiciary, the judges only choose the one way, which can be very betterly solved in the other way if it could have been taken into consideration. So in such cases, like what is your view whether it's not hampering on the good governance and also the democratic setup of the country?
Yes, sir. I first of all, I'll answer this in a two-parter. First of all, I agree completely with your premise that there is that the court. The point I was trying to make under the third section of my presentation and my paper, which is selective judicial leaps, I try to argue that there is a reverse construction that the court always does, and not just in this case, but other multiple important politically sensitive cases where it seems as if to the media and to the common public and anybody involved and interested in the law that there is an outcome that is already decided. Most, even in civil society, already discussed among themselves. Colloquially in Hindi they would say, "Ha, faisla to तय हो चुका hai." All that is going to happen right now is that the official judicial pronouncement will happen for that. I think it is bad personally, because one of the biggest things about the Supreme Court lies as an institution, not just in India as one of the greatest in terms of setting the law, but also across South Asia. Supreme Court precedents from the 60s and the 70s and the 80s have been taken as precedent in courts of Kenya and in courts of Myanmar because of how judicially succinct they were. Now, the problem is that the Supreme Court keeps speaking about an erosion of public trust. Whenever it starts contempt of court proceedings against somebody, whether it's Prashant Bhushan or a newspaper for saying something negative of the Supreme Court, it says that this might erode the confidence of the people or the public in the Supreme Court of India as an institution. I think more than these comments, it's its own judgment, like you have pointed out, its own understanding and its own its own selective interpretation, its own selective leaps. Now, not just me pointing this out, but even other individuals, even laymen who read a newspaper and understand what the judiciary is doing, how exactly it's responding to certain things. For example, the UGC guidelines that were just stayed by the Supreme Court. Why was that particular thing stayed, but something else that the government has been doing has not been stayed? All of these questions, when the public starts asking, I think the legitimacy of the Supreme Court falling in the eyes of the common public is far higher by its own actions than somebody else criticizing. Criticism is part of any particular democratic ecosystem, which in this case Umar Khalid and other people have also showed us: criticism against the government, criticism against the judiciary. But when the judiciary itself gives us examples within its own judgments that it is being contradictory or it is being extremely selective, I think faith in the public institution of the judiciary falls and goes beyond the point of recovery if it continues to go on that path. So I completely agree with your point, sir, and I think the future currently is bleak, but it is not completely lost. Thank you.
Okay, for a researchers like us, like you, it is our duty to remind the policies, how the government can mold, even the courts can mold. I will want you to research more upon the development of the judiciary in US,
Yes, sir.
like how they had come up with not selectivism but the authority. Their principle of judgment is based on authority. More authoritative the way is, that way would be the judgment. It's not like
Correct.
random the ways are being provided, you have to choose one. It's not like that. The more authoritative the way, the more far better the judgment is. So you have to look upon all those principles, US Supreme Court principles, to even come with a certain conclusion, even give a authoritative conclusion. That would be suggesting you.
Okay. And that I'll make that change in my next presentation, sir. Thank you so much.
Okay. Yeah, we can move ahead with the next presenter.
Thank you.
Thank you, participant. Our next presenter is Mohit Singh, along with co-participant Divya Mani from Assam University. You can now proceed, Divya Mani.
Good evening, respected chairperson, distinguished participants. Hello, am I audible?
Yes, you are audible. You can start. Yeah.
Yeah. Good evening, respected chairperson, distinguished participants, and my fellow presenters. I am Divya Mani, co-author of Mohit Singh. We are students of BA LLB Honours from Assam University, Silchar. Today, I'll be presenting our paper entitled Cross-Border Data Flows versus Data Localization, Analyzing Privacy Risks and Solutions in Contemporary South Asia. Let's start with the introduction. South Asia stands as a crossroads between two competing paradigms of data governance. One side, cross border data flows enable innovation, improve user experience, and economic integration via global digital networks. On the other side, localization mandates storing data within territorial boundaries to assert digital sovereignty and regulatory control. The tension is not merely technical, but deeply constitutional. Now, moving towards the constitutional foundation of this topic. In the landmark Puttaswamy ruling of 2017, the Supreme Court of India unanimously recognized privacy as a fundamental facet of Article 21 and said that it is essential to human dignity and autonomy. The rights must travel with the data even when it crosses international borders. Now let's examine the regulatory landscape of South Asia. India is a leader in digital infrastructure and legislation, but faces gaps in cross-border oversights. Sri Lanka has adopted Personal Data Protection Act of 2022 and GDPR aligned framework that focuses strongly on data protection rights. Meanwhile, Pakistan's draft Personal Data Protection Bill of 2023 remains stalled. It faces high risk of data misuse and lack of enforcement. Moving towards moving towards the gaps within India's framework. The Digital Personal Data Protection Act of 2023 adopts a blacklist model where data flows abroad by default unless explicitly banned. However, unlike the GDPR, there are no adequacy checks before transferring data. This creates the risks that data may end up in jurisdiction with weaker privacy norms. Additionally, enforcing data Indian rights outside the territory remains a legal challenge. To better understand the consequences, let us look at some real world harms. Inadequate relations have enabled surveillance and exploitation. For instance, Pegasus scandal of 2021, Bangladesh bank heist of 2016, and blasphemy entrapment. Now let's move towards recommendations. The first one is pre-transfer risk assessments. Evaluate privacy risks before data abroad. The second one is contractual safeguards. Use regulator approved clauses to protect data intentionally. Localization for sensitive data. Keep health and biometric data within national borders. Number 4. Data protection impact assessments. Continuously assess risks before processing personal data. The number 5th is the regional cooperation promotes shared standards and joint enforcement across South Asia. The number 6 is regulate secondary use and algorithms, ensure transparency to prevent misuse and discrimination. To conclude, privacy is a regulatory hurdle but a prerequisite for inclusive development. An adaptive constitutional and regional approach is essential for achieving true digital sovereignty. Thank you.
Okay, participant, what are the country models you had assessed?
Country models are Sri Lanka and Pakistan also.
Okay, well, like what are the outcome findings of your assessment?
Findings are like, sir, I have mentioned some recommendations like how we can improve. Some of them are like pre-transfer risk assessments, like we can predict what will happen, how our privacy will remain safe.
See, India has already enforced DPDPA, Digital Personal Data Protection Act. Okay, so
Yes,
now
sir.
tell me whether that act will help and will resolve all our problems that we have been facing in the digital era, or like the act is yet to get such kind of enforcement.
No, sir. As I can think, it can't solve our problems like that. It does not, because sir, it does not provide any regulations or because in matter of cross border data flows.
All right, we can move ahead with the next participant. Thank you.
Thank you, participant. Our next presenter is Dhriti Chabra, who's a practicing advocate at Delhi High Court.
Right. Thank you so much for introducing me. I'm also simultaneously, I'm also pursuing my master's from NLU Delhi currently. So today I'll be presenting my paper on constitutional implications of prejudicial oral remarks by higher courts on the right to fair adjudication and judicial independence in India. Now, before I move forward, there's just a short disclaimer that there is. So, considering the nature of my research, I just want to clarify that this comes part of fair criticism, and what I've said in my paper is also a part of fair criticism and should not be taken otherwise. I have the utmost respect for the Honorable High Courts and the Supreme Court. Now, I'll move on to the main argument that I'm trying to make. So, my paper argues that prejudicial oral remarks by higher courts have the potential to not only impact the independence of the subordinate judiciary and other quasi-judicial authorities, but also the right to fair adjudication and thereby cause negative constitutional implications. Now, in order to prove what I've just said, the very first section of my paper draws upon the premise that I've stated. So the higher courts in India exercise considerable influence over the decisions of the courts and other quasi-judicial authorities that are subordinate to them. And I've tried to basically argue that this influence is not only formal, but it also can be informal, and which is vital to my research, the paper that I'm trying to prove in terms of oral prejudicial remarks. So the informal remarks that Supreme Court makes, they have a high influential character. And I've tried to prove this through various citations that I've mentioned. Now, this influence is, of course, due to the hierarchy that is there and also because of the institutional nature of the higher court. So lower courts tend to follow what the higher court says because they don't want ultimately their matters to be reversed in appeal. And also, there are also chances of the collegium that they would like to maintain. And of course, because of the institutional nature, they would like to maintain the same order as has been indicated. I would use the word indicated by the higher courts in their oral remarks. Now, the next section of my paper contextualizes the right to fair adjudication. And I've mentioned a few landmark cases as well. And I just reiterated that fair adjudication necessitates the absence of external influences and inherent biases in judicial decision making. So what I've said is that basically oral remarks can sometimes impact the real likelihood of bias as well as the reasonable apprehension of bias. And if they get attracted, it is very difficult to maintain the constitutional safeguard of fair adjudication. So next, I've pointed out towards the constitutional implications of prejudicial remarks, and I've taken up certain case studies wherein certain oral remarks have been made by the higher courts, and in this particular case, the Honorable Supreme Court. So I just want to point out that, of course, I have taken these from Live Law and Bar and Bench, and these are valid sources. So we all are aware about the case of Beer Biceps. So in this matter, I'll just point out, because of brevity of time, I'll only pointing out one comment that the court made. So if this is not obscenity, then what is obscenity? And and we need to keep in mind that Ranveer Alabadia's case is actually pending. The FIR is against obscenity, which is pending currently. But this is what the court said. Now, I'll point towards another case study. So in a matter in October, if you might remember, so the court, Justice Surikant, made certain comments regarding UNHRC's functioning, and it was said that they are basically opened a showroom here, and they are issuing certificates too, and we don't want to comment on them. But I'm sorry to say they did comment on them. And ultimately, the matter of the Sudanese refugee is currently pending before the UNHRC itself. And it is surprising that while the court expects UNHRC to be fair, UNHRC on its own website has reiterated in a PDF all these comments of live law, which the Honorable Court has made. So basically, what I've tried to done is that I've tried to connect these to my initial argument, if you may remember my premise, that the Honorable Higher Courts exercise influential control over the lower courts, and then I've also connected to the right to fair adjudication. Of course, I understand that this is not an empirical study. If given the time, I would prefer something empirical, but this is the doctrinal analysis that I've done. Now that we've identified the problem, the solution also has to be determined. Now, I'm not saying that there should be a complete gag or a complete ban on the Supreme Court saying anything orally. It's not like that. And I've also not said that there should be not reporting at all. So what I'm pointing towards is that there is a necessity to maintain judicial propriety and restraint. Now that my time is almost over, I'd just like to reiterate that in the matter of Salim Bhai Memon in 2021, the Honorable Supreme Court itself had observed that the element of judicial accountability is lost where oral regimes prevail. And I'd like to finish with that. Thank you. Now I'm open to any questions if there are.
Okay, what are your solution to these challenges which we had been facing in the democratic setup?
Correct, sir. So, right, just as I have pointed out, the solution is not that there should not be any reporting. The solution is also not that the Supreme Court should stop commenting at all. I understand that in a lot of cases, the courts do play the role of the devil's advocate, and it's necessary to have a conversation. But the solution which I'm pointing towards is that there is a necessity to maintain some kind of judicial restraint in matters which are pending adjudication. So like the matter of Ranveer Alabadia, so it was pending adjudication, and like the matter of the Sudanese refugee, it was pending adjudication, and certain comments were made regarding the very merits of the case or regarding the parties of a case. Now what that does is that causes an influence not only on the lower courts, of course, but it also causes an influence on the general public. So that itself affects the lower courts. So this is the solution that I'm getting at. There has to be some judicial propriety. There has to be some restraint.
As the earlier participant, I will tell you also, like, to look into some of the principles from the US. Like already there has been much jurisprudential development with respect to the court system and how to administer the justice. I will like ask you to also look into their doctrine, into the development of the US Supreme Court and their policies. So there lies, because we have to understand, till now, that is 2026, we are having, yet there are a number of high courts are not having their guidelines, their rules of the high court rules. So that's one of the major reasons, like we don't have the documentations how to come up with the proper judgment. We don't have the guideline for the judges and also the courts how it to be run. So we have to look into how to develop the policies where the honorable judges and also the bench, also the bar comes to certain kind of framework where these loose lapses doesn't go hand in hand, rather it gets rectified before. So I will ask you to look into the US policies.
Absolutely, I agree. And I think I've looked at a few US cases, and there are studies empirically which have been conducted in the US regarding this very issue. But this is something which is lacking in India. And I think I agree with you. This is something that we can work with as researchers, as well as the Supreme Court. Of course, there needs to be some sort of uniformity which is required. Thank you very much for your comments. I'll incorporate them.
All right. Yeah. We'll be moving ahead with the next participant.
Thank you, presenter. Next participant is Dr. Swati Saxena from Asian Law College.
Yes, so very good evening, everyone. Just
Yes,
starting with
sir.
my PPT. Oh, just a second. I have to share the screen for this, right? Screen.
All the participants kindly keep your presentation loaded to avoid any delay.
Just a second, sir.
Yes, your screen is visible, madam. You can just share your presentation.
Yes, sir. I hope the PPT is visible, sir.
Yes, it is visible. You can start.
Okay. So, the topic for my research paper is the role of Lokpal in strengthening the rule of law in India. Now, basically, the abstract deals with how this Lokpal and Lokayukta Act that were enacted by 2013, they established a powerful anti-corruption ombudsman aimed at strengthening accountability, the rule of law, and public trust. So, basically, there has been a genesis of corruption in India, and to counter it, the Lokpal and Lokayukta Act was established. This study critically evaluates Lokpal's autonomy, neutrality, and effectiveness while comparing it with global ombudsman models to identify gaps and propose reforms. So, what I've done is I have outlined the act of Lokpal, how autonomous it is, whether it is neutral or not, and how effective it is. And then I've also compared it with global ombudsman models, particularly citing Sweden, Australia, and UK models. Now, these are the three research questions that are there in my research paper. So first is, how does the Lokpal help maintain the rule of law and democratic accountability within India's governance framework? Second is, what are the critical administrative and structural limitations that impede the Lokpal from effectively combating corruption? And third is, how effectively does India's Lokpal aligns with global ombudsman models like Sweden and UK to promote transparency? Now, what has been the background? So we already know that pre-independent era also and post-independence, particularly during the license Raj era, there has been a lot of corruption, majorly because of the permission related to license, and this also led to a lot of bribery and nepotism in the system. And what was the impact of this license Raj system was there has been an erosion of public trust, economic inefficiency, and it hindered development welfare. Now, there has been major key scandals that has happened in India in the past. For example, if we talk about the Bofors scandal that was related to the defense procurement, there was a lot of bribery that was involved. There has been a Commonwealth scandals. There has been 2G spectrum scandals, fodder scandals, and there has been Colgate scandal. So one of the major legislation that was passed in 1988 was the Prevention of Corruption Act that was enacted majorly after the Bofors scandal that was related to the defense procurement. Now, why there is a need to have an ombudsman at that time was because of accountability deficit. So there was traditional mechanisms that were already there, but they were not able to check the kind of corruption that was there, particularly the political corruption that used to prevail during those times. In fact, it is still there. Public demand, because citizens became aware and they asked for a more transparent and citizen-centric governance. We also talked about good governance, and more methods of transparency should be included in this governance method. And there has been an institutional gap. There was a need for an independent body free from executive control to investigate maladministration. Now, this is something that is a very crucial point, that this independent body should be free from executive control. But what we can see today is, even after the implementation of Lokpal in India, it is still not free from executive control because the selection committee involves a major hold of the executive. This is some of the estimate that I have shown, that around 1.76 lakh crore has been loss in the 2012 Colgate scandal, just to emphasize the amount of corruption that was prevailing. Now, this has been the establishment structure and mandate of the Lokpal. Genesis, if I talk about 1960s, the first ARC reforms also recommended for an ombudsman model. 2008, second ARC also recommended the same. In 2011, because of the efforts of Anna Hazare sir, India Against Corruption movement was launched and it created mass mobilization. In 2013, this act was passed by the parliament. President's assent received in January 2014. But it took almost 5 years for this institution to officially operationalize with the first chairperson. The reason was because one of the a major person that is involved in the selection committee is the leader of the opposition, but there was no leader of the opposition till then. So this was a major thing that has happened. Later on, it was said that even from the largest party, there is a leader of opposition. That is also something that is permitted. So only in 2019, this officially came into operation. Now, what is the composition? There are 8 members that are required. The selection committee comprises of the Prime Minister, CGI, Speaker, Leader of the Opposition. Mandatory quotas is 50% of this. Out of these 8 members should be the judicial members, and 50% representation should also be given to SC, ST, OBCs, minorities, and women. But we can see that from the criteria or from the present status is this 50% representation criteria is also not always fulfilled. Preliminary inquiry will require 90 days. Initial scrutiny will happen within these 90 days, and full investigation will take 6 months. Now, again, what is the clause is this Lokpal does not have its own investigation agency. It heavily relies on CBI and CVC for the same. Now, if we talk about the effectiveness, assessments, gaps, and challenges, what has been the critical limitations is I have jotted down the important limitations or certain things that are still hindering the effective implementation of Lokpal. First is delayed operationalization. 2013, the act was passed, and I already mentioned it was operationalized till 2019. There is no suo motu powers that are given to the Lokpal, so it cannot investigate particularly on any politician or any agency on its own. It requires a party to intervene. There is structural dependence. It lacks in own investigation wing, and it heavily relies on CBI for inquiries, as I've already mentioned. There is procedural complexity. It's high rejection of complaints due to technicalities are there. So a normal common man cannot understand the technicalities that are involved. Appointment issues, vacancies, and delays that I've already mentioned are there. Limited outcomes, very few prosecutions or convictions despite thousands of complaints. So complaints are in thousands, but prosecutions and convictions rate is very less. Judicial overlaps, confusion with CVC and departmental vigilance creates ineffectiveness because there is heavily reliance on CVC and CBI for its investigation. And there is transparency gaps, limited public reporting. So on the website or nowhere the case statistics or, a public reporting is there of the Lokpal. So this again creates a lot of public distrust. Now, if I talk about the global comparisons and lessons for India, so there has been global successful models when we come to ombudsmen. For example, Sweden, New Zealand, Australia that I've mentioned. So CPI is the Corruption Perception Index score. So it rates the country out of 100. The score is given on the basis of how accountable or how transparent their ombudsmen are.
Participant, you had exceeded the time. You can conclude.
Okay. So just moving towards the proposed reforms that I am suggesting is, first of all, constitutional status should be given to Lokpal, just as we have given it to the Election Commission of India. Second is its appointment. The selection committee's appointment should be independent of the executive. So there is heavy reliance of executive in the selection of the Lokpal and its committee members. That should be avoided. Suo motu powers should be given to the Lokpal. That means it can investigate proactively without waiting for formal complaints, similar to that we have seen in the Swedish ombudsman model. Direct investigative capacity, that means again there has been a heavy reliance on CBI and CVC, as I mentioned. So we should establish a dedicated independent investigative wing for the Lokpal. Whistleblower protection, this is again not mentioned in the Lokpal. The whistleblowers are not provided a lot of protection mechanism. And there has to be a lot of transparency that has to be ensured. The public trust can only come if there is major transparency in the implementation process of the Lokpal. What has been the way forward is that I have suggested there is operational efficiency. Operational efficiency is something that we should achieve. So fill all the vacancies promptly, publish comprehensive annual reports to restore trust and streamline complaint procedures. Medium term roadmap is structural autonomy. So we should give a lot of autonomy to the Lokpal so that it can investigate on its own. There should be less reliance on CBI. We can again think about an agency that can come up in order to serve the purpose only for the Lokpal. And long term is a constitutional status should be given to the Lokpal in order to have more autonomy and independence. Over here, I want to conclude this, sir.
Okay, now when we looked into the Indian context, as you already mentioned, that
Yes, sir.
the autonomy is required. So my question to you is, even if you had considered some of the Western like country models, as you already mentioned, so
Yes, sir.
what are the successive rate to those countries? Even the cases are registered, even the Lokpals are proactive in those countries. What is the success rate? Like how many government ministers has been detained, or how many public servant has been detained? So even in those cases, we see the success rate is merely very less. Like even the countries which you had termed it, I can guarantee you the major reason behind is like it's not about making a department or making a agency proactive. It's about how efficiently the judiciary or the independency of the system can work. So I will suggest you to look into some of the report by IDEA. Like you can look into the IDEA's report regarding the democratic reform and democratic governance, where the proactive mechanisms has been recommended for many years. Like it has been 7-8 years now. You can
Yes,
look to
sir.
all those reports and can find how we can come up with such policies where not only India, even the South Asian regions is filled with such kind of political dramas where one party during the election sends ED to the other states where
Yes.
parties are not having the majority. So all these are political drama, and ultimately, if you are telling that on the recommendation that it should get a status in the constitution, like the election commission in
Election
India we
Commission.
are having, yeah. But what is the purpose? The purpose is to come up with more democratic process, but rather
Yes.
it transforms into it's a power making process where the political power is just snatched with respect to the constitutional power. So this has to be think, and your paper title suits best to look into all those perspectives.
Sure, sir. I'll study more related to it. The suggestions that you have given, I'll surely try to incorporate it, sir. Thank you so
All
much, sir.
okay.
Thank you.
We can move ahead to the next participant.
Thank you, participant. Our next presenter is Jaya Krishnan CD. You can now proceed.
Good evening, everyone. So, first of all, my apologies for the camera. Some technical issues there with my camera, so this won't be available. Still, I will be presenting my paper. All right. So, my topic here is digital constitutionalism with a South Asian perspective. All right. Now, the objective of this paper is basically to examine how the growing use of technology by the state for governance has expanded its surveillance powers also, and how that has become a concern with regard to constitutional rights such as privacy, liberty, and democratic accountability. Now, one of the most important thing was during early times, human presence and human effort was required only for the purpose of surveillance. But today we see today without even our knowledge, surveillance operates, that too in a silent mode with the help of data, algorithms, and automated systems. Now, when I talk about digital constitutionalism or digital governance, I stick to three important parts, that is constitutionalism, digital constitutionalism, and algorithmic surveillance. These are the key concepts with regard to my paper. Now, we know that constitutionalism implies the limitation of the governmental power in order to protect the individual rights and also to maintain democratic governance within a society. Now, when we import that into the digital realm, that constitutes what is known as digital constitutionalism. Now, on the other side, we have algorithmic surveillance. We have heard about surveillance by police through their physical presence or by other means. But today, the most understood form of surveillance among us citizens is algorithmic surveillance or surveillance using advanced technologies. Now, the core problem here is that this type of surveillance, it poses a very significant challenge to citizens because it is operated through an opaque mechanism, and it is not accountable for any of its actions, be it to the person who was made a victim to that. And very often, it intrudes into the rights of individuals, such as personal liberty, privacy, etc. Now, my core research question over here would include whether the constitutional limits in South Asian nations are reshaped with the rise of algorithmic surveillance, and if so, what are the necessary safeguards that can be implemented in order to ensure democratic resilience? For that, I have pointed out three factors: privacy and liberty, due process and equality, and also problem recognition. Now, impact on rights. We have seen the judgment of Justice K.S. Pottaswamy that is recognized right to privacy as a fundamental right. But when we talk about algorithmic surveillance, it threatens our fundamental privacy and liberty. Therefore, the judgment of Pottaswamy is reduced to mere paper, to mere writing on a paper. And moreover, this type of surveillance, it also creates a chilling effect with regard to free expression and democratic participation. The best example for that, which can be cited, is the Pegasus case, which happened around 2023, 2023. Then, due process risk. We know that the AI systems operate within black boxes, and the method which was used to predict such a decision, it is never released to the public. So a person can't know as to how he was convicted, or he was being mapped, or he was made a victim in that particular case. And what do you say? It is also not open to challenge. So they are denied of a fair procedure. Then, with regard to equality and bias, this is one of the most biggest issues, because the use of algorithmic surveillance tends to map mostly these marginalized societies, people belonging to marginal groups, or maybe the minority groups. They are mostly mapped, and they are made accountable for no actions which are not been committed by them. This was first recognized in the USA in the case of William Roberts. Now, when we talk about when you take a South Asian surveillance comparison, I have mapped 4 countries: India, Pakistan, Sri Lanka, and Nepal. India, we know that we have the Pottaswamy judgment that gives us a fundamental right to privacy, and also the Anuradha Bhasin judgment that lays down a test of proportionality. But still, the Pegasus allegations, it still brings great concern to us with regard to surveillance by government using technological methods. Pakistan, on the other hand, Article 14 of the Pakistan Constitution, along with various precedents, have actually upheld privacy to be a fundamental right. But still, through the use of certain laws, which are also draconian in nature, for example, the Pakistan there was a Pakistan Electronic Communications Act, PEC, 2016, and the Pakistan Telecommunication Act. These 2 acts they are found to be very much draconian in nature. So there is no enforcements that are there which can help protect people from such state action. Sri Lanka, it does not have any laws that protect privacy. So there are huge legislative gaps, and also there is also lack of accountability. And Nepal, it has a beautiful legislative structure with regard to privacy, but still the implementation of all the provisions is very weak, and therefore citizens can be exposed to unregulated monitoring. Finally, with regard to the recommendations which I have suggested, 1, there should be clear legal frameworks that has to be established in order to govern surveillance practices and also protect the citizens' rights. Then, with regard to surveillance measures, in order to test it, the best test to rely for that is the test of proportionality. And there should also be a judicial oversight about actions of surveillance. That is, algorithmic surveillance should be subject or made amenable to judicial review. And also, there should be independent audits that must be conducted with regard to surveillance systems. And in case if there is any violation of fundamental rights by such instruments or by such algorithms, then the appropriate remedy should also be suggested and provided. With that, I conclude my presentation. Thank you.
Okay, participant, you had mentioned that the surveillance should be proportional, like the doctrine of proportionality, basically. But when we looked
Yes.
into when we looked into various aspects of state surveillance, we generally
Mhm.
see that the state is always coming up with this excuse, like a state security or like a national sovereignty. So these are the excuses. So
But
what is
but that has actually been that has actually been what do you say? It has been said that the state cannot use such cover. That has been held in the Anuradha Bhasin judgment, in the Madhyama Media One judgment, and also in the
But
Pegasus
on a
order. It has
practical
been
note,
given.
I'm giving you a practical aspect of it.
Right.
Recently, just in 2023, BNS Bharatiya Nyaya Sanhita came into existence, and in that we see under section 152, the state has been provided. Like though the government repeatedly told us, even the Honorable Home Minister of India came into the dais and he spoke that we are removing or omitting the seditious laws or the seditious provision. But again, when we looked into the section 152, it gives two broad definition: the any action against the state are punishable. So it is a sedition. So like question towards this is not right or wrong. It's about how much it is infringing a individual right, or how much the state can exercise to infringe upon the individual right upon the term or upon the exception of the state surveillance.
Okay. No, but
So yes, my
no, but
suggestion would be to consider this type of questions into your research.
all right. I will definitely consider it, sir.
Okay. All right. That was my only suggestion. I don't have any question for you. Do consider these aspects and include in your research paper.
I hope I was able to make my presentation well and good, and I hope it is understandable.
Yeah, it was understandable. Thank you. We can move ahead with the next participant.
Thank you so much.
Thank you, participant. Our next presenter is Mamta, along with co-participant Dr. Vijay Shri Dubey Pandey from Christ University, Delhi. You can proceed with your presentation now.
Participant, you are not visible and audible. Participant, you are not visible or audible. No, you are not audible. You are just visible. We can't hear you. A host, can you listen her?
No, sir, she's not audible.
Okay, you might be facing some technical issue, participant. We can call you after one participant. If the should, okay, yeah, we can move ahead with the next host.
Okay, sir. Our next presenter is Kshitij Kumar Oja from Guru Gobind Singh University. Okay, you can proceed with the presentation now, Kshitij.
Is my screen visible?
Yes, it's visible.
Right, thank you. Could you please excuse me because I have very limited internet connection, so I won't be able to share my video with you. I can start.
All right, participant, you can start.
Thank you so much, sir. I'll be presenting as the topic suggests. My topic is Statute over Constitution, the Umar Khalid Verdict 2026. Let me start by saying that we are actually witnessing a defining constitutional conflict in India today. The clash between national security statutes, specifically the UAPA and the fundamental right to liberty under Article 21, My paper that I've written critiques the Supreme Court's January 2026 verdict in Umar Khalid versus State of NCT of Delhi. In this case, despite the accused serving 6 years of incarceration without a trial, the court denied them the bail. So this marks a drastic retreat from the 2021 Najib precedent, which held that prolonged delay effectively melts down statutory restrictions. So through this presentation, I will demonstrate how the court has now shifted its interpretative focus from the infringement of rights caused by delay to the gravity of conspiracy based on police allegations. My central argument is that this verdict validates a dual state system where the process itself becomes the punishment, and Article 21 is rendered largely illusory for political detainees. So to understand this barrier, we can look at the UAPA section 43D or subsection 5. So it mandates that if an accusation is prima facie true, bail can be denied. Under the Vatali precedent, under the Vatali doctrine, courts must accept prosecution evidence as truth without questioning it. So this actually creates a jurisprudence of suspicion where this narrative. But as I said, there is the Najib precedent, the Najib judgment in 2021 that provided some kind of hope. The Supreme Court in the Najib case ruled that statutory restrictions cannot override the fundamental right to a speedy trial under Article 21. It actually established that where a trial is indefinitely delayed, the rights, or rather the rigors of bail, that provision must met verdict. This spending 6 years, in detention.
Participant, your voice is not perfectly audible.
The Umar Khalid judgment actually introduces a dangerous innovation, that is the hierarchy of culpability. It distinguishes between ideological drivers, that is the masterminds, and the footholders. So bail was granted to ancillary participants, but it was denied to Umar Khalid and Sarjil Iman, who were considered the mastermind. This implies that conceptualizing a protest is now equated with orchestrating terror, which can be said that it criminalizes intellectual dissent. The court also expanded the definition of terror, relying on by any other means clause under section 15 of the UAPA. It held that destabilizing civic life, even without immediate violence, it can constitute a terrorist act. This vague interpretation blurs the line between constitutionally protected protest and terrorism, leaving very little room for political dissent. But this leads us to a legal anomaly because there was a judgment, Delhi High Court's judgment in Tana case, Asif Iqbal Tana, where the Delhi High Court actually attempted to distinguish protest from terrorism in a strict sense. Yet, the Supreme Court ordered this judgment not to be treated as a precedent. While the accused who were released through this judgment, they remain free. The crucial legal reasoning given in this judgment is now blocked, which allows the state to continue utilizing, broad terror definitions. So the core argument is that process has become, punishment. The court has shifted focus from the infringement of rights caused by delay back to the gravity of police allegations. So when the seriousness of unproven charges outweighs the presumption of innocence and years of imprisonment, the legal process itself becomes the primary tool of punishment. So in conclusion, we are actually witnessing the ingraining of a dual state. For a specific class of political detainees, normative principles like bail and speedy trial, they're systematically being suspended. So the verdict basically confirms that for these individuals, the protection of Article 21 is largely illusory, which legitimizes a status quo of indefinite detention without trial. Thank you so much.
Okay, what is the solution you are coming up with?
So the solution is to for the courts is to actually stick to the precedent which has been set. So, for example, in this very specific case, in the Umar Khalid case, the Supreme Court completely ignored the judgment that it already had given in the Najib case, right? And then the other one in the Tana case, the Supreme Court actually, even without having actual jurisdiction over the fact that they disallowed the High Court judgment to act as a precedent, which it cannot really do, because the High Court are also the constitutional courts, and you cannot the Supreme Court doesn't have the power to ask a judgment of the High Court not to be taken as precedent. So the court really needs to actually stick to the precedent that have been set previously, so that there is a there is a continuity in terms of UOPA judgments.
All right, participant. We can move ahead to the next presenter.
Thank you, participant. I would like to recall Miss Mamta now, since she faced some microphone issues. I would like to put her on stage. Mamta, is your okay? Wait a second. No, you're not audible, Mamta. No, you're still not audible.
You can try rejoining again. Move to the next presenter host.
Okay, our next presenter is Apurva Singh from Gujarat National University, Silvassa. Apurva, you can start with your presentation.
Am I audible?
Yes, you are audible.
Yes,
you are
yes,
not
you are audible.
You can present your presentation.
Okay. Is my screen audible? Is my screen visible?
Yes, kindly turn on your camera, Apurva.
Sir, I have some electricity issue on my end, so I won't be visible, I guess.
Okay,
Sir.
okay. You may continue with the presentation.
Okay, thank you, sir. Good evening, everyone. Today I will be speaking on evolving constitutionalism in India, classical foundations and contemporary judicial innovations. This presentation examines how Indian constitutionalism has developed from its classical roots, focused on limiting state power, to a more transformative model that actively seeks social justice, dignity, and democratic accountability. To begin with, constitutionalism is not merely about having a written constitution. It is the idea that all public power must operate within defined legal limits. At its core, constitutionalism prevents arbitrariness. It ensures that government actions are controlled by law rather than personal will. Classically, constitutionalism emphasized three main elements: the rule of law, separation of powers, and accountability mechanism. In its traditional understanding, the Constitution acts primarily as a restraint on power. Moving forward, I will discuss the key features of classical constitutionalism. As I have also stated earlier, classical constitutionalism rests on three foundation principles. First, the rule of law, meaning no authority is above the law and all individuals are equal before it. Second, separation of power, which divides authority among legislature, executive, and judiciary to prevent concentration of power. Third, the idea of limited government, where the constitution sets clear boundaries that the state cannot cross. Importantly, this model focuses on structural safeguards rather than achieving social or economic justice. When we come and see our Indian constitution, the Indian constitution was deeply influenced by these classical ideas. It adopted constitutional supremacy, judicial review, and a functional separation of power. However, the framers did not apply these ideas mechanically. Unlike purely classical models, the Indian constitution also introduced DPSP, which imposed positive obligation on the state to promote welfare and social justice. Thus, from the very beginning, Indian constitutionalism combined restraint with transformation. Now I will discuss why classical constitutionalism was not enough. Despite its strength, classical constitutionalism was insufficient for India's realities. India inherited deep social inequalities, caste hierarchies, economic disparities, and gender injustice. A model that merely limited government power could not address structural discrimination. The constitution was therefore envisioned not only as a shield against state excess but also as an instrument for social change. This tension between restraint and transformation became central to Indian constitutional development. Shift to transformative constitutionalism. Over time, Indian courts began interpreting the constitution in a transformative manner. Transformative constitutionalism views the constitution as a tool for achieving substantive equality, dignity, and inclusion instead of focusing only on procedural legality. The judiciary emphasized fairness and justice in substance. Rights were expanded through interpretation rather than formal amendments. The constitution was no longer seen as static, it became a living instrument responsive to social realities. Judicial innovation played a decisive role in this transformation. Article 21, originally narrow in scope, as we see in Eko Gopalan case, was expanded to include rights such as livelihood, privacy, and a clean environment. The judiciary strengthened judicial review to protect constitutional values from legislative or executive approach. Courts increasingly relied on principles such as constitutional morality to safeguard dignity and minority right.
The
Thus, the
recommendation and
judiciary.
suggestions. Come to
Yes,
the
sir.
recommendation and suggestions.
Okay, sir. So challenges I would write. I would like to discuss the contemporary challenges that we face. So, despite these advancements, Indian constitutionalism faces serious challenges. There are concerns regarding expanding executive authority and the weakening of deliberative processes. Majoritarian pressure sometimes threaten minority right. At the same time, judicial overreach is debated, particularly in context of policy intervention. Furthermore, there exists an implementation gap. Constitutional promises do not always translate into lived realities. Thus, I would like to conclude. Thus, Indian constitutionalism represents a dynamic balance between limitation and transformation. Its classical foundation, rule of law, separation of power, constitutional supremacy remains intact, yet through judicial interpretation, it has evolved into a transformative framework centered on dignity, equality, and justice. The Indian constitution is not frozen document, it is a living system that adapts to societal change while remaining anchored in foundational principles. Thank you.
Okay, Miss Apurva, have you mentioned about the principle of C3 from the Professor Upendra Bakshi? It's very relevant to your topic.
Okay, sir, I will look into it. So, can you
Okay.
please repeat it? Principle of
Three C's. Three
three
C's.
C's.
Yeah.
Okay, sir.
Principle of three
Okay, sir.
C's from the Constitution, like Professor Upendra Bakshi has been provided. Very beautifully,
Okay,
he had narrated that principles. So you can
okay,
refer to those, and it's very relevant towards your topic.
okay, sir. I will definitely look into it.
All right, yeah.
Thank you, sir.
We can move ahead to the next participant.
Okay, thank you. Thank you, Apurva. Our next participant is Kunal Gautam, along with co participant Sonali Kumari from Amity University, Jharkhand. Mr. Kunal, you can now proceed with your presentation.
Good afternoon, sir.
Participant, you are not visible. Kindly turn on your camera and share your presentation.
Sir, am I visible right now?
No, you are not. Your presentation is also not visible.
Sir, actually, we are facing some glitches in our network this area. So I think my video will be I'm not visible. I think so. So I would seek apologies for this thing, sir.
But your presentation, PPT, is also not visible.
Yes, sir. Just a minute, sir. So is it visible right now?
Yes, it is visible.
And I'm so sorry that my video is not I'm not visible to you, sir. Shall I proceed, sir?
Yes, proceed with your presentation.
So, good evening, sir. This is Kunal Gautam, and with my co-author Sonali, we are going to present our PPT on transformative constitutionalism code as an agent of social change. This presentation explores the radical shift of the constitution from a static character of the governance to a dynamic instrument designed to reconstruct a society on a foundation of dignity, equality, and freedom. We begin by examining the transition from formal equality, which often leaves the marginalized with only a illusionary promise of liberty, to substantive equality, where the law actively dismantles the enrichment of hierarchies. The judiciary act as a vanguard of this social revolution by utilizing agents of change such as procedural innovation, public interest litigation, and remedial power like structural interdicts. However, this change creates a counter majoritarian dilemma, a tension point where the protection of minority rights by other
Participant,
judges.
your slides are not moving.
Yes, sir. Just a minute, sir.
Yes. Okay, you can directly go to the your challenges and your findings and recommendations.
Sir, first three slides are being dealt by me, and other three slides will be concluded by my co-author Sonali. So, if you are okay with it, then I should proceed to the core findings. And
Yes, yes, no issue.
a central finding of our research is the dynamic partisan shift in the constitutional theory. Traditionally, the constitution was viewed as a shield instead to limit state power and prevent the status quo. The transformative constitutionalism remains it as a sword used to proactively dismantle inequalities. This evolution moves society from a culture of authorities where the state word is final to a culture of justification, where every exercise of power must be justified by constitutional principles of equality and dignity. In this view, the constitution is a living instrument that must evolve to meet the contemporary social needs. Now, other slides are being dealt by my co-author Sonali. Over to you, Sonali.
So the key findings, which includes procedural evolution, and the second is the enforcement of social economic rights, and last challenges and the final observation. Procedural revolution. A primary tool is liberalized access, that is local standing. By relaxing traditional rules, court allows any public citizen to litigate on behalf of those who lack resources to do themselves. This is supported by purposive interpretation. Purposive interpretation is an approach where judges interpret the text in light of the constitutional core values like dignity, equality, and social. And the third is the structural interdict. It is an enforcement tool, also known as continuing mandamus, allows the court to keep cases open for years to monitor government compliance with its order. Next is the socio-economic rights. We can see example of POCL versus Union of India. The court managed food security policy for over a decade to ensure the implementation of midday meal scheme. And the case of right to housing, that is South Africa case, government of the Republic of South Africa versus Grootboom. The Constitutional Court ordered the state to devise and implement a comprehensive program to provide relief to those in desperate need, like house, food, and so on. Now, the challenges and final observation, which is first is the core majoritarian dilemma. In this, there is a fundamental tension regarding
unelected judges, overruling the policies of elected representatives. Second is the institutional capacities. Courts often lack the technical expertise and budgetary control to manage complex social reforms. Third is the implementation gap. Many rulings result in paper victories or hollow hopes, where litigants win in the court but see no changes in daily existence due to a lack of enforcement. Fourth is the future outlook. The research suggests a move toward dialogic constitutionalism, where courts identify flaw but collaborate with the legislature for remedies. Thank you.
Okay, participant, what are the country models you have taken for policy recommendation?
So we have basically focused on three countries like the India, South Africa, and Colombia. And mainly we have focused on the Indian judicial part. Am I audible, sir?
Okay, out of all these three country model, what is the best policy from which country you had recommended?
So we have examined all the three countries' judgment, and we have came to a conclusion that Indian judiciary system has, though it has a very lacuna in their judgment, but they are more reliable than other countries, sir. Their judgments are very
Try to include this South Asian regional perspective within your country models and go for the analysis, the comparative analysis with all those countries.
Sir, as the study help the society by providing a roadmap for dialogical constitutionalism, a model where the court identifies unconstitutional flaws but collaborate with the legislature to craft a sustainable policy remedy. Sir, our research serves as a testament to believe that when the law is wielded with empathy and courage, it possesses the unique power to heal historical wounds and engineer a more human collective existence.
All
Sir,
right. All right, participant. My suggestion is you should include a South Asian perspective, that is a regional view of South Asia with a comparative analysis with your subject topic. So that's my suggestion.
Okay, thank you. We will definitely
Yes.
cooperate, sir. Thank you so much.
We can move ahead to the next participant.
Okay, sir. Okay. Thank you, participant. I would like to re-invite Miss Mamta. She said that her microphone issues resolved. Okay. Let's see.
Am I audible now?
Yes, you are audible, Mamta.
Okay. Good evening, sir. So I would like to request an exemption for the video because I think there is some network issue. That's why my audio was not audible to you earlier.
Okay, no issues. Just share your presentation and you can start with your presentation.
Okay, thank you, sir.
Okay, host, we have two participants in the waiting area where their connectivity camera is not connected. That's why they can't be added. You can inform them priorly.
Okay, sir. I will inform them.
Yes, like participant, kindly share your presentation.
Yes, sir, it's processing. Just a moment.
So all the participants, kindly keep your PPTs loaded without any delay. Yes, you can start.
Okay, sir, thank you. So I will be presenting the paper titled The Right to be Forgotten and Digital Constitutionalism, an empirical analysis of judicial balancing in India from 2017 to 2015. This paper examines how Indian courts balance digital privacy with free speech, open justice in the post Puttaswamy judgment. After Justice K.S. Puttaswamy 2017 judgment, privacy was recognized as a fundamental right extending to informational autonomy. However, digital records today are permanent and searchable, unlike human memory. This creates a constitutional conflict between right to be forgotten and Article 19, Clause 1, Clause A, freedom of speech and open justice. Indian courts currently resolve this conflict case by case without a settled standard. The research question of this paper are first, how courts have the balance, a right to be forgotten
Participant,
and
you
free
can skip
expression.
participant, you can skip the research questions and research objective. You can straightly go to the challenges and your solutions.
Okay, sir. So the paper is grounded in digital constitutionalism. Privacy after Puttaswamy is understood as a self-determination, but must be balanced against the democratic accountability. I apply a proportionality framework evaluating legitimacy, necessity, and balancing of interest to assess judicial reasoning. Sir, empirically, courts have implicitly acknowledged the right to be forgotten but have not formally codified. A clear trend is preference of de-indexing rather than deletion. So, courts also rely on constitutional privacy principle than the DPDP Act 2023. And the outcomes of my empirical research is that the finding shows that 100% success for crime victims, 93.8 success for private individuals, and there has been 0% success for public figures and governmental records. The recommendations which I'm giving through my paper is that first, explicit statutory recognition of right to be forgotten in DPDP Act should be given. Second, a structured proportionality test of courts should be there. And third, protection of open justice, which ensures an exceptional remedy, should be there. And lastly, a clear intimidatory obligation to avoid private censorship. So, to conclude, the right to be forgotten in India remains a constitutional dilemma and not merely a data protection issue. So, a judicial responses are cautious but inconsistent. A constitutionally granted framework is required to balance privacy with the domestic transparency. That's all for my presentation, sir.
Okay, you are talking about right to be forgotten with respect to the digital platform, right? If I'm not
Yes,
wrong.
sir.
Okay.
Yes, sir.
Now here the two aspect of right to be forgotten will come into existence. Every time we browse a data like a website or it can be any online platform, we are leaving our digital footprint. So
Yes,
there,
sir.
it's already a cryptic mechanism where our footprint are digitized wherever we would be visiting or wherever we would be going. So here no control is provided to any of the government or any places. Let's say you are visiting a random website. Here even the website owners are having control to certain extent where the servers are of third party and the other parties are also involved. So you cannot, even the government don't have the control. So my question to you is how the government would be managing with this kind of, how government will tackle with this kind of challenges in order to in order to even order, like let's say court is ordering the right to be forgotten for your identity. The court
Yes,
is
sir.
ordering that all the digital footprints to be deleted, but how it would be exercised, how it would be practically feasible?
So it could be practically feasible if government issues or make up some policy which states the clear rules, legal rules with regard to the platforms, like what content they can hold for themselves and which type of information they should
Already we are
delete.
having rule number 4 and rule number 3 from the IT rules, where the government or the intermediaries are having that obligation to come up with the due diligence mechanism. Even in the DPDPA, we are having DPDPA due diligence. So government has made enough rules for regulating the intermediaries or the platforms. But my genuine concern towards your topic is how to come up with the the deletion of the digital footprints, which is not at all possible. So I will tell you to refer some of the interesting observations from the United Nations Internet Governance Forum. You can look into their policies, also some of the conference notes or the forum notes regarding these topics. They had also deliberately discussed upon this. If any of the, because these are not digitized thing, this is not unified or centralized thing. Like once you visit a random website, even the website owner don't have full access of your footprint. Yeah, the footprint access is divided with number of third parties. So they
Yes.
cannot simply, even the government simply cannot order that your footprint would be completely deleted. So you should explore more topic, like more into this topic and go relevance, yeah, how relevant it is. We cannot blindly say a government to delete something or to do something where the authority itself doesn't lies with the government, right? Like I will try you to explore the topic more and to delve into in more detail so that the suggestions and the problems can be figured out.
Okay, sir. Sure, sir. I'll do
All
it.
right, yeah, we can move ahead with
Thank
the
you.
next participant.
Okay. Okay, sir. Thank you, participant. Uh, our next presenter is Yashashwi Singh from Gandhinagar, from Gujarat National University, Gandhinagar. No, Yashashwi, you are not audible.
Participant, you are not audible. You can share your presentation. Participant, kindly speak. No, you are not audible. No, you are having the same issue like the previous participant. You are not audible to us. You can try rejoining. We'll be calling you after one participant.
Okay. Our next presenter is Gautam S. Along with the co-participant Dravya K. Ashok from School of Legal Studies. Uh,
Am
you're
I
not
audible?
audible, participant. Oh, yes, you are audible now. Yes.
Kindly share your presentation.
Yes, just
All of you kindly keep your presentation loaded. We are already delayed about 10 to 20 minutes.
sorry. Is screen visible?
Yes, yeah, your screen is visible. You can start.
It's still visible, right? So good evening, everyone. Am I audible?
Yes, go ahead.
Okay, good evening, everyone. So my presentation is on the case comment of the Association for Democratic Reforms versus Union of India. So this landmark judgment was on 2024. This examines whether anonymous political funding can coexist with a constitutional democracy. Going on to the introduction of this paper. So this electoral bond scheme was introduced into 2018 following the 2017 union budget, and it allowed individuals to contribute and individuals and companies to donate to money to political parties through SBI bonds while remaining completely anonymous. So to facilitate the scheme, several amendments were made to multiple laws, including Companies Act, Income Tax Act, Representation of People Act, and RBI Act. So the stated objective was to reduce the black money
by shifting donations to banking channels. However, the real consequence was total secrecy in the political funding. So this was challenged by this petitioner was the association called Association for Democratic Reforms and CDIM Party and Common Cause to a public litigation. So issues before the court was the first whether the electoral bond scheme it violated Article 14 and Article 19 Clause 1 Subclause A. Second, whether the voters' right to information was compromised. And third was whether unlimited corporate funding created this arbitrariness. And the fourth was whether this legislative amendments enabling secrecy were constitutional. And the these were the issues before the court. And moving on to the judgment. So in February 2024, the Constitution bench headed by Chief Justice D.Y. Chandrachud unanimously struck down this scheme. So the court held that this anonymous political funding violates the Article 19, Clause 1, Subclause A, because voters have a fundamental right to know who finances the political parties. So the court reiterated that this comes under purview of the Article 19, Clause 1, Subclause A, and it directed this SBI to disclose donor information and ordered the Election Commission of India to publish the data. So this is what the court held it, and the judgment was dismantled this political funding secrecy. So coming on to the expansion of this Article 19, Clause 1, Subclause A, what court reaffirmed was that the freedom of speech includes the right to receive information. So it's just not only a freedom of expression and speech, it also includes the right to know, which is the right to receive information. This judgment also relied on precedents like PUCL versus Union of India, State of UP versus Raj Narine. And also the court reiterated that the voting is not merely a casting a ballot, it is an act of expression based on informed choice. So political funding directly influences policies and governance. The voters must know the financial backers of parties to meaningfully participate in the democracy. And what is coming to the government? Arguments, what is the defense? So the union government defended the scheme by arguing that donor privacy and black money prevention, and what court applied was the test of proportionality, which is from the Puttaswamy case. So what court said was, while donor privacy was recognized as legitimate, the method adopted was the absolute non-disclosure. Also, it was failed the least restrictive means. So the court clearly that the voters' right to information, this outweighs the donor anonymity. So keeping the donors anonymous literally out voters' right to information is above the donors' anonymity, and transparency cannot be sacrificed for convenience. This is what the court of the judgment. Coming on to the role of election commission. So by the virtue of Article 324, court recognized the election commission.
You can come to these conclusions. You can come to the conclusion.
Yeah, sure, sir. Yeah, sure. So coming on to the conclusion of this judgment, coming to conclude, this case is a very landmark judgment, which upheld the Article 19, Clause 1, Subclause A, and it expanded its meaning. So it also stands as a constitutional milestone judgment. So this transforms electoral transparency from a procedural requirement to more of a constitutional mandate. So it reinforces that democracy is not merely about election, it is about informed participation. By expanding this Article 19, Clause 1, Subclause A, this empowers the Election Commission, and dismantling the anonymous funding, Supreme Court reaffirmed that an informed electorate is the foundation of the legitimate democracy. Thank you.
Okay, this was a case analysis, right?
Yes, sir. This was a case comment.
Okay, for a case comment, try to include some of the like referred international assessment. Like for this case, you can refer to some of the surveys by the IDEI, and also like for the Collegium. Recently, even the Election Commission of India held one of the conference, just very recent, like I believe this month or the in January last week, it might be it might have been held. So we just looked into the conference report of ECI. You will see this case and the other case which is relevant to this has been written. So try to write your paper in a manner which benefits. It's not just a merely case comment; it should benefit for the report, right?
Yes, okay, sir. Thank you, sir.
Okay, yeah, we can move ahead with the next participant.
Thank you so much,
Okay,
sir.
thank you, participant. I would like to recall Yashasvi Singh from GNLU. She had some microphone issues. I would like to recall her. Hello, participant. Participant, you're still not audible.
No, your issue is not resolved. You can.
No, participant. You're not audible.
Okay, we can call someone else.
Okay. Our next presenter is Arpit Yadav, along with co-participant Dr. Sudhir Kumar Chaturvedi. Arpit actually isn't in the call. Participant was here a minute ago. Okay. Next, I would like to call Devakar Dalmia from Gujarat National Law University.
Am I audible and visible?
Yes, participant, you're audible and visible. Please continue with your presentation.
And is my screen visible?
Yes, participant, your screen is visible.
Okay. Thank you. So, good evening, respected chair and learned participants. I am Divakar Dalmia, and today I will be presenting my paper titled Rights in the Shadow of Security, Proportionality and Strict Scrutiny in India and the United States. This paper examines how constitutional courts balance between two competing imperatives, that is, protecting individual liberty and safeguarding national security, through the doctrines of proportionality and strict scrutiny. Now, traditionally, Indian courts followed the Wednesbury principle of reasonableness, where intervention was limited to decisions that were so unreasonable that no reasonable authority could have met them. However, proportionality represents a heightened scrutiny. It is used by courts to examine whether restrictions on rights are constitutionally justified. And this proportionality test consists of four stages. First is the legitimacy stage, second, suitability, third, necessity, and fourth is the balancing stage. Now, the doctrine originated in 19th century Prussian and German administrative law and later developed through European Court of Human Rights. In India, its evolution has been gradual. In the case of Anuj Garg versus Hotel Association of India 2007, the court looked at less restrictive alternatives, though it did not formally structure the proportionality test. A major shift came in the case of Modern Dental College of 2016, where the Supreme Court expressly adopted the four-part test, although the application of it was not deeply structured. This marked the formal recognition of proportionality in Indian constitutional law. Now, the Aadhaar cases further developed the doctrine. In Bijoy Vishram, the court accepted proportionality but largely stopped at the suitability stage. In Puttaswamy versus Union of India right to privacy case, the court declared privacy a fundamental right and held that any restriction must satisfy the proportionality test. Finally, in Puttaswamy's second judgment, that is the Aadhaar judgment, the court applied all four stages to assess the Aadhaar Act. This firmly established proportionality as the governing standard in rights adjudication. Now, the real challenge arises in national security cases. So, first, I would like to take the case of Anuradha Bhasin versus Union of India 2020, which concerns with the internet shutdown in Jammu and Kashmir.
Here, the court recognized that internet access affects freedom of speech and trade. However, it did not impose a strict evidentiary burden on the state to justify the necessity of a complete shutdown. In contrast, in the case of Internet and Mobile Association versus Reserve Bank of India, the court applied the necessity test more carefully and struck down the RBI's ban on cryptocurrency exchanges, holding that less restrictive alternatives were available. Thus, proportionality in India has been adopted, but its intensity varies, especially in security sensitive cases. Now, moving on to the United States, unlike India, the US does not follow proportionality. Instead, it applies the strict scrutiny test, which is the highest standard of judicial review. Under this test, the government must prove three things. First is that there is a compelling state interest. Second, that the law is narrowly tailored to achieve that interest. And third, that the means employed are the least restrictive option available. This test is rigid and often results in invalidation if any of the prong fails. It reflects a constitutional philosophy that places strong suspicion on governmental interference with fundamental rights. Moving on to the cases with regards to strict scrutiny in USA, in Ashcroft versus American Civil Liberties Union, the US Supreme Court struck down a law restricting online speech because it was broader than necessary. Next, in the case of Hamdi versus Rumsfeld, the court held that even in times of war, indefinite detention without due process is unconstitutional. Lastly, in the case of American Civil Liberties Union versus Clapper, the bulk telephone metadata collection program was invalidated as the government failed to show that such extensive surveillance was necessary and narrowly tailored. So, American courts thus generally demand stronger evidentiary justification from the state. So, to conclude, both proportionality and strict scrutiny aim to balance liberty and security, while proportionality offers flexibility and contextual balancing. Strict scrutiny offers stronger structural protection but less flexibility. The effectiveness of either doctrine ultimately depends on how rigorously courts demand evidence, justification, and accountability from the state. In the end, the preservation of liberty depends not only on the doctrine adopted, but also on how courageously it is applied. That's all from my part. Thank you.
Okay, what are the country policy models you had referred, participant? Like, have you referred any of the country policy model?
I'm sorry, sir, you are not audible to me.
Okay, I'm asking you, have you referred any of the policy model of countries regarding your topic concern? Host, am I audible to you?
Yes, sir. Yes, sir. You're audible.
Okay.
I think the issue is from the participants' side.
All right. We can move ahead with the next participant. Thank you. There's no
I
queries.
think, like for me, the organizer is audible, but sir's voice is not audible.
Okay. No problem, participant. We can now move on.
Okay.
Thank you, participant. Our next presenter, I would like to recall Yashasvi once again. Yashasvi Singh from GNLU. Hello, participant. Participant, I think you're facing some internet issues. Your video is stuck as well.
If your internet issue is not resolved, you can turn off your camera, participant. There is no issue. Just your audio has to be perfect. No, participant, your audio issue is not resolved. We can move to the next
Okay,
host.
okay, sir. Okay. I would like to call Arpit Yadav. Our next presenter is Arpit Yadav.
Hello.
Yes, you're audible,
Yes, good
participant.
evening. Yes. Good evening to the panelist. Hello. Yes, sir. Uh, my topic of presentation is freedom of information regime in South Asian countries, a comparative analysis with India. So why, like, we are running out of time, so I am directly coming to the question that why I have chosen this topic, that I have analyzed the various information laws in the South Asian countries, in which I have taken Sri Lanka, Bangladesh, Pakistan, and the countries like Nepal. So with this, I will directly come to the challenges, because as we know, we are running out of time, so I'm skipping this introductory part, because as we know that these laws, like information laws, are basically dependent on the basis of transparency and accountability. So it is the responsibility of every democratic country that the country have more transparent and accountable towards the citizens of their country. So it is a mandatory for any democratic country that they should have these information laws. So I have analyzed the information laws in the South Asian countries where we have democracy also, and what I found the challenges regarding it, that like I have already mentioned in this slide, that I have analyzed this right to information act in India, that is Pakistan's right to access to information laws, and the Bangladesh, Nepal, and Sri Lanka. So I'm coming directly to the challenges. What I found the challenges in these South Asian countries, that they're not that much able to implement these laws as we have, like in India. Like if we compare it, or if we look into the current scenario, then we will find that in most of our South Asian countries we have political instability, and there is a direct relationship of these information laws, that that any country who want to excel in this field, like they wanted to provide more information to the citizens of their country, then there must be political stability in their country, because there is a direct relationship, because providing information to the citizens is a part of constitutionalism. And in any like in any democratic country, if there is a political stability, then only they can focus on this aspect, that this is the part of the constitutionalism, and then they have to provide these kind of laws to their citizens. And definitely, because there is a political instability, the democratic values are down in our neighboring countries, in South Asian countries, then there is a lack of awareness among citizens also about their rights. And because of political instability is the only reason that these all are problems are arising in a particular country. So if you talk about that, whether the law, that is right to information act in 2005, comparatively is stronger than the rest of the South Asian countries what we have, like Bangladesh, Pakistan, then definitely, because we are more sound democratically, as well as we are following the constitution strictly. So conclusively we can say that we have information laws better than the South Asian countries. But definitely, what we have also, we can also have some improvement we can do, like a recent what I found recently, that the like in news, that the appointments are very much delayed, and the appointments which is made by the central government, that is the main chief election commissioner, his name is coming in Epstein files. And these are the concerns which we have to resolve. We have to ensure that whatever appointments we are making in this post, that the person must be have a good character, that the person must have a sound background, then only in our country also these laws can be truly effective. That's all from my side, sir.
Okay, what according to you are most pressing issue regarding the democracy is concerned presently in South Asia?
Sir, like sir, we have an example of Bangladesh. In India also, sir, we are looking that the political parties, they don't have trust in this electoral politics, sir. So the most of the thing is that the main concern of the distrust is that, sir, the citizens are like they are not believing in the political system, like especially the election process is what we have seen in Sri Lanka also, what we have seen in Bangladesh also, and these type of concern are also raising in our country also, sir.
Go. All right, participant. Thank you.
Thank you so much, sir. Thank you.
Thank you, participant. Now I'd like to call our next presenter, Mr. Mansingh Dhundiram Bisure.
Yes, I am audible, sir.
Participant, you can proceed.
Yes,
you
I am
are
audible, sir.
Yes, participant, you
participant,
can
you are.
share
Yes,
your
yes.
presentation.
Sir, my PPT is visible.
It's not visible till now.
Yes. Yes, it is visible, sir.
Yes, kindly go ahead with your presentation. Yeah.
Yes. So myself, Mansingh Dusure, and along with my co-author, Amsit Birazar. So the topic of research is balancing national security and constitutional liberties, a critical study of anti-terrorism laws. So the issue of terrorism has suffered as one of the most significant challenges facing contemporary constitutional democracies. So acts of terrorism are inherently designed not only to inflict physical damage but also to generate fear, disrupt political institutions, and weaken public trust in the rule of law. So in reaction of these threats, nations worldwide have implemented extensive anti-terrorism legislation aims at thwarting attacks, dismantling terrorist organizations, and safeguarding national security. So now we can see here the conflict between security and freedom. So the clash between national security and personal freedom is grounded in political philosophy, constitutional theory, and public law. So anti-terrorism legislation functions at the crossroads of these areas where the government's responsibility to safeguard its citizens conflict with its obligation to honor and maintain individual rights. So grasping this tension necessitates an analysis of the theoretical foundation for a state authority, the constitutional boundaries on that authority, and the normative principle that regulate the limitations of rights. So we can see here now international legal frameworks and standards. So the global legal approach of to terrorism functions within a multifaceted structure aimed at balancing state sovereignty, collective security, and safeguarding of human rights. So although international laws acknowledges the rightful concern of states in fighting terrorism, it also enforces normative limitations on the formulation and extensive execution of counter-terrorism strategies. So these limitations mainly stem from international human rights law, international humanitarian law, and United Nations counter-terrorism frameworks. Collectively, these systems set forth baseline standards that regulate the equilibrium between national security and constitutional freedoms. We can see here anti-terrorism laws and constitutional liberties, a comparative analysis. So anti-terrorism laws in various jurisdictions share a unified goal of thwarting and curbing terrorism. However, the constitutional ramifications of these laws differ greatly based on legal traditions, institutional protections, and judicial practices. A comparative study of specific jurisdictions, specifically the United States, UK, and India, uncovers both similarities and differences in how democratic nations reconcile national security with constitutional rights. So, although their constitutional structures vary, each jurisdiction faces comparable issue concerning preventive detention, surveillance, freedom of speech, and due process. Now, we can see here the judicial view. So case studies offer tangible insights into the functioning of anti-terrorism laws in real-world scenarios and judicial responses when constitutional freedoms are challenged. Although statutory analysis outlines the extent of governmental authority, court rulings reveal the actual impacts of counter-terrorism policies on personal rights. So this section explores three important case studies from the United States, UK, and India, emphasizing judicial perspective on detention, due process, and executive discretion within the framework of national security. So now we can see here the critical issues and debates. Despite the declared aim of safeguarding national security, anti-terrorism legislation has sparked ongoing discussion regarding its effects on constitutional governance, civil liberties, and democratic accountability. Although government defend extraordinary legal actions as essential reactions to unprecedented dangers, opponents contend that these laws frequently surpass their rightful boundaries, leading to widespread rights infringement and normalization of exceptional authorities. This section explores the most urgent legal and constitutional challenges that persist in influencing the disclosure of on anti-terrorism laws. Now we can see here the reconciling security and liberties, principles and reforms. So balancing national security with constitutional freedoms necessitates a principled legal structure that views security and liberty as complementary rather than opposing values. Anti-terrorism initiatives must be rooted in the rule of law, ensuring that any limitations on rights are exceptional, justified, and subject to rigorous oversight. So the legality principle requires that counter-terrorism legislation be explicitly defined and narrowly focused to avoid arbitrary and discriminatory enforcement. Ambiguous legal language erodes legal certainty and heightens the potential for misuse. So we can come to the conclusion here. So the ongoing threat of terrorism presents significant challenges to contemporary constitutional democracies, forcing nations to implement extraordinary legal measures under the guise of national security. Nevertheless, as this research illustrates, the legitimacy of anti-terrorism legislation is contingent not only on the success in curbing violence but also on its alignment with constitutional freedoms and the rule of law. Historically, context and comparative legal studies indicate that when security concerns overshadow fundamental rights, the repercussions frequently involve executive overreach, a decline in due process, and the marginalization at risk communities. So, at the last, I would like to quote one quote. A nation's true security is not measured by how forcefully it confronts terror, but by how faithfully it protects the constitutional liberties that define its democracy, even in moments of fear. So, thank you, sir.
Okay, as you well stated, now I will mention in number of occasions or in this session to number of participants. I had already mentioned this before. We see in many places, specifically laws, such as the laws like sedition in India. Presently, the government claims that the sedition is not a law, like they had curtailed the sedition, but in section 152, we again looked into the same wordings of sedition, just with a change of the scope and the paraphrase. So, section 152 of the BNS has completely came up with the same impact or the effect of the law, which was earlier in the sedition. So, what your perspective? Whether this kind of laws should impact the democracy, or it has any implication, positive implication, in order to tackle terrorism?
So yes, these are the valid provisions regarding to tackle the terrorism, according to my perspective.
Okay, according to your perspective, now, like, what according to you uh, is valid in order to, if you looked into the law, here the wordings are as such that any activity which hampers the government or which makes the government unpleasant are to be termed as a illegal activity. So how you will come up with this broad definition of illegal activity, or what, how we will determine those activities?
So, sir, every freedom is not an absolute one. So, government can impose such type of restrictions.
That is definitely true, but does it falls under the criteria of reasonable restriction under article
Yes, yes,
19.1?
sir. Yes, obviously, sir.
Okay, I will insist you to read some of the literature from
Okay,
the
okay, sir.
jurist of liberty, and come up with those principles which we, because we cannot see just one side of the coin. We as a researcher have to look into what's this implication. Even in Supreme Court, like the provision which I mentioned, section 152 of BNS is under challenged under the constitutionality. So let's see how the turns comes, and as a researcher, to keep our mind always fresh for the perspective. So I will insist you to come up with both sides reasoning and to look what is the authority and what is the formulation and what is the practical implementations on the ground where the people has to suffer or the government suppresses the masses. That's how
Yes, sir.
I'd
Yes, sir.
like you to look into. Yeah.
Yes, sir. Yes, sir. Thank you, sir.
All right.
Yes, sir. Thank you, sir.
All right. Thank you, presenter. I would like to recall Yashasvi once again. Uh,
Am I audible now?
yes, participant, you're audible.
Okay, I'll just share my presentation. Is the PPT visible?
No, participant, your PPT is not visible.
Wait, I'm trying. It's just processing.
Participant, you can start. Your PPT is loaded.
Yes. So good evening, everyone. My name is Yashasvi Singh, and I'm here to present on the topic Beyond Monolithic Identity, Horizontal Reservations in the Pursuit of Substantive Justice in India. In this paper, I have explored the evolution of equality in Indian law. The paper argues that our legal system is moving away from a formal, arithmetic understanding of equality towards transformative constitutionalism. As Austin famously noted, the Indian Constitution is not just a law, but a social revolution. It seeks to break the structured hierarchies of caste and gender to provide substantive justice. Vertical versus horizontal models. For decades, India relied on vertical reservations, fixed quotas for scheduled castes, scheduled tribes, and other backward classes. While transformative, this model treats identities as monolithic, assuming caste is the primary axis of oppression. However, identity is not one dimensional. A Dalit woman or a person with a disability experiences intersectionality, a confluence of overlapping disadvantages. This is where horizontal reservation comes in. They cut across vertical categories to address status based disadvantages like gender, disability, and sexual orientation. Now we'll talk about the doctrinal shift and the migration problem. A significant hurdle has been the formalist trap. After the landmark Indra Sahni case, many administrative bodies treated reservation categories as rigid, separate compartments. This led to the migration problem, where meritorious candidates from reserved categories were often denied seats in the open category. This effectively transformed the open category into a protected zone for the upper caste and penalized merit among the marginalized. Now, the paper highlights that merit is not just an exam score, it is a product of social structure. Now we'll talk about the case of Saurabh Yadav, which is the case of Saurav Yadav versus Uttar Pradesh serves as a watershed moment. The Supreme Court moved towards an intersectional approach, prioritizing substantive justice over bureaucratic convenience. Globally, this puts India in a unique position. While the US has retreated from affirmative action in cases like Students for Fair Admissions, India is increasing its sophistication. Like South Africa, India recognizes that true equality can only be achieved through differential treatment. We still face challenges, a lack of comprehensive intersectional data, and the myth of merit used to argue against efficiency. To fulfill the constitutional promise, the paper suggests three steps: codifying horizontal adjustment principles in all service rules, providing universal horizontal reservation for transgender people, and conducing intersectional data audits. In conclusion, horizontal reservations are not just administrative tools, they are instrument of social liberation. As Dr. B.R. Ambedkar foretold, political democracy cannot survive without social democracy. By embracing intersectionality, we move closer towards a justice that is not just sameness but true liberation. Thank you.
Okay, participant, what according to you should be the solution for these reservations and the other system which you had elaborated?
Sir, as I have said, that there has been vertical reservation since the time of Constitution was written, but we must identify the intersectionality in these reservations. For example, as I said, a Dalit woman faces double marginalization. So, according to me, their horizontal reservation is equally important to vertical reservation, and some reservations horizontally should also be made constant in all the vertical reservations as well, made uniform.
All right. Have you mentioned about the rationals of the Indra Sahani judgment?
In my paper, no, sir. I have just taken the conclusion out of it and tried to incorporate in my paper so that whatever the Indra Sahni judgment said, it could be become conducive of the paper as well.
All right. Try to assess the drawback or the uh, backdrop of the Indra Sahani. Also, what are the implications the judgment faced? There are some of the critiques also of this judgment. Looked into to those.
Sure, sir. I will.
All right. Yeah.
Thank you, sir.
We can move on to the next participant.
All right. Thank you, participant. I would like to invite now Dr. Swati Vinay Srivastav to present their presentation.
Yes, Dr. Swati, you can share your presentation.
Yes, sir.
Yes, your screen is visible. You
Yes.
can start.
Yes, sir. Hello, everyone. South Asian Conference on Constitutionalism and Democratic Governance. My topic is democratic accountability of the executive branch. So first requirement of accountability for the executive branch, why it is needed. Democratic accountability by the executive branch, it is fundamental in our constitution. And Bentham once said, the more strictly we are watched, the better we behave. Accountability, sir, it is closely associated with the authority. Where there is authority, there is a power, and you use power towards the public, then it's your accountability to prove. There is a big difference between responsible and accountable things. Responsible is a desirable character for leadership, but accountability needs to be checked whether it is reasonable or not. That means executive should be reasonable towards the public. So I want to tell the things. Constitutional provision of executive power of the union and state government. Constitution Article 73 as well as 162 of Indian Constitution says and deals with executive power of the union and state respectively. So categorically laid down that the executive power is coexistence with the powers of the respective legislature to make law. Sir, in that provision, union government has power to make law for the central territory and state government has power to make law for the state. So provided that in any matter with respect to which the legislature of a state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. Let me tell you one thing about the part 4th of the constitution. It is very much related to the executive power because the state works towards the welfare of the public. So there is a responsibility of the executive to fulfill all the gaps between the legislature and the public and give all the facility to the public. Part 4th has directed the state to attain the higher objectives of social and economic justice by ensuring the citizens have adequate means of livelihood, equal payment and equal work, decent standard of livelihood, proper nutritional standard, access to social security and legal aid. Then part 4th of the Constitution provide widen scope for the executive branch to work for the public welfare. So, and as well as plays vital role for executive to use discretionary power. That is main thing I want to tell you, the discretionary power towards public policy and its implementation for the public. So in Indian Constitution, there is many bodies which is public administrative bodies, and that bodies works toward the public. So in that body also we have a discretionary power. So that body should properly work towards the discretionary power. The Indian Constitution has created and recognized as a number of administrative bodies such as Election Commission 324, Public Service Commission 315, All India Services 312, Finance Commission 280, Interstate Water Dispute Authority Article 262. These administrative authorities were granted lot of discretionary powers to make subordinate rules, decide quasi-judicial issues, and to take administrative action. So the basic thing is to how to control executive discretion. There is two way control over executive power by the parliament and the judiciary. There is two way, either by the parliament or by the judiciary we can control administrative action. So Edward Coke, he made the famous observation, power corrupts and absolute power corrupts absolutely. So adequate center should be exercised over the administration by means of political checks through the parliament and legal central through the process of judicial review. It is a main function to check the administrative discretionary power. With the increasing of the function and powers of the administration, it was felt necessary that these should be an adequate check on the working of the administration so as to prevent abuse of power, which will be determined to the welfare of the people. So needs to control. Why it is needed? Because it is the constitutional need to control exercise of discretionary power. In Menka Gandhi versus Union of India, it has been earlier emphasized that application of constitutional provision under Article 14 and 21 in exercise of discretionary power, and stated that Article 14 strikes at arbitrariness in state action and ensures fairness and equality of treatment. The principle of reasonableness should not be left, which legally as well as philosophically is an essential element of equality, or non-arbitrariness pervades all Article 14 like a brooding omnipresence, and the procedure contemplated by Article 21 must answer the test of reasonableness. In order to be in conformity with Article 14, it must be right and just and fair and not arbitrary, fanciful or oppressive. Otherwise, it would be no procedure at all and the requirement of Article 21 would not be satisfied. Basis of judicial review. There is a basis for the judiciary to check whether this administrative action is violating fundamental right or civil right of the person or not. Illegality. Illegality is the first basic to check the administrative action. So illegality expresses the idea that the decision maker must understand correctly the law that regulates his decision making power and give effect to it. Thus, the decision maker is expected to act for a purpose. And for that, and he must apply correct test, must take into account relevant factors and disregard irrelevant factors. It is necessary for the administrative officer who has discretionary power towards the public. Then second one is the decision and administrative authority is also irrationality, is also bad, where it is to so preserve that no reasonable decision maker could have made such a decision. Judicial review on this ground is around the exercise of discretion by a leading authority. It is comparatively softer than illegality. As court accorded sufficient latitude to a decision maker before declaring his decision as perverse, the ground of irrationality is often used when there is no clear basis for review on ground of illegality. this is the judicial norms to check the administrative action or discretionary power, but there is a procedural impropriety in it. Involves a failure on the part of the decision makers to apply the rules of natural justice where appropriate, to act fairly, and to observe procedural norms establishes by the statute. It produces a refinement of the principle of audi ultram partem. It can be put into two groups: breach of principle of natural justice, not affording a fair and reasonable opportunity to meet the case. And there is another way other than judicial review of administrative action has been further widened by a number of non-statutory rules. Such rules are Wensbury rule of reasonableness, violation of the rule of natural justice, principle of proportionality, promissory estoppel, and legitimate expectation. So I am concluding my paper with that. There is many policy. Legislation is working towards the public, but there is a bridge between the legislature and public. So that bridge is executive branch should work properly and reasonably towards the public. Then only it is possible to maintain democratic governance and good governance, and that accountability needs to check by the judiciary, either by the judiciary and by the public participation. It is my conclusion over the paper. Thank you for your time and attention. I appreciate the opportunity to share my perspective and engage in this meaningful legal discourse. Thank you, everyone.
Okay, so Dr. Swati, you had well explained about the executive's role. But here the major concern of South Asian region is the executive is not checked in a proper way, because ultimately when we looked into the authority towards which the executive is tied is the legislature, the ministries or the departments. So
Yes.
how to come up with the proper checks? Even like if we go to the judiciary, here again one issue with the judiciary. Just in today's session, one of the researchers from the Supreme Court of India, he has presented his paper, and he mentioned that the selective judgment is going on in the courts itself. Like there are three ways to give the judgment for a case, but the judges pre-decided that they should be go by that particular way, not on the other two ways. So it's very selective mechanism, of the selective judgment is going on even in the courts. So how to come up with this kind of issues like which we are facing?
Sir, basically, there is a judiciary to check the administrative discretion, but we need some of authority to check the executive power in the district level, in the state level, so they can check whether it is whether they are working properly or not. Only judiciary is not the way to check the executive powers, because it is a day by day affairs to the public. See, once you go to the collector office, there is a power which is discretionary used by the collector for the public. So it is possible by the judiciary every day to check the power of to see the discretionary power of the collector, how he is using, whether he is using reasonably or whether he is using judicially. It is not possible. So we have to make the sum of option for the executive itself to check the discretionary power first, and then second step to approach to the judiciary. In between that, suppose there is a violation of civil right and fundamental rights, then we go to judiciary.
Okay, all right, Dr. Swati, thank you for your presentation.
Thank you, sir. Thanks.
All right, thank you, Dr. Swati. Now I would like to invite Janvi Singh from Rashtriya Raksha University, Gandhinagar, to present. Participant, you may now proceed.
Hello, is I audible?
Yes,
participant, you're audible.
Yeah, you may turn
actually, I have some network issue, and earlier I was unable to unmute, and right now I am unable to share my screen.
You are unable to share your screen?
Yes.
Then how we will assess your presentation?
So can we do on another app like Zoom or something?
not possible. It's completely binding upon the rules.
Yes, sir, I understand.
Okay, you can present, but if you just present without your presentation, then you have to turn on your camera.
Okay, sir.
Okay, sir. Okay, sir.
Okay, sir, actually, I'm so sorry for the like issue which is created by me. Sir, basically, my topic is comparative public law and transnational constitutionalism. Sir, basically, my paper examined the relationship between the comparative public law and transnational constitutionalism in the context of constitutional education, particularly in the global south, in an era marked by globalization, democratic backsliding, and expanding international human rights regimes. Constitutional courts increasingly engage with foreign jurisprudence and transnational norms. And this raises a fundamental question: how can court draw from global constitutional ideas while preserving democratic legitimacy and constitutional sovereignty? The central problem of my paper is like, despite this growing engagement, constitutional scholarship remains largely state centric. Much of them literatures assume that in constitutional interpretation is an inward looking exercises with insufficient attention paid to how courts, specifically in post colonial jurisdiction, navigate transnational constitutionalism influences. The problem is not whether courts borrow from abroad, but how such borrowing is justified, structured, and democratically anchored. My research question and argument is, so basically transnational constitutionalism means that constitutional ideas like human right, dignity, and rule of law travel across countries and influences courts beyond national borders. And comparative public law is a method of comparing constitutions, while transnational constitutionalism explains how constitutional norms move and influence different countries. So this paper asks how domestic constitutional court use comparative public law to engage with transnational constitutionalism norms, and this engagement means for democratic reliances. I argue that transnational constitutionalism and comparative public law are distinct but interdependent. Transnational constitutionalism explains why constitutional norms travel across borders, while comparative public law supplies the methodological discipline that determines how these norms should be used. The next one is conceptual clarification. Comparative public law is better understood as method of constitutional reasoning. It allows court to examine foreign doctrines, institutions, arrangements, and imperative techniques in order to refine domestic constitutional understanding. Transnational constitutionalism, by contrast, is a phenomenon. It describes how constitutional principles such as dignity, proportionality, or judicial independence circulate across jurisdiction and gain persuasive authority without formal incorporation. So I have also mentioned the case of Maneka Gandhi versus Union of India, and in this case, the Supreme Court explained Article 21 by incorporating substantive due process, drawing incapability from comparative constitutional traditions. Another case, that is Visakha versus State of Rajasthan, in international human rights instruments such as CEDAW were used to fill legislative vacuum, not as binding law but at interpretative aids. Most notably in the Justice K.S. Puttaswamy versus Union of India, relied on comparative jurisprudence from multiple jurisdictions to recognize privacy as intrinsic to dignity and democracy, while grounding the right firmly with India's institutional structure. So, moreover, the doctrines such as reasonableness and substantive due process in the basic structure doctrine functions as constitutional filters. And like this, and my the basically, sir, my paper does not deal with the the wrong sides of comparative public law. This paper mainly focus on using the jurisdictions as comparative references to explain transnational constitutional influences, and it is used in a it is used in a positive way. And the major recommendation which my paper suggested is adopt a structured comparative method, prioritize constitutional context, ensure democratic justification, and develop a judicial guidelines. And my conclusion is transnational constitutionalism and comparative public law should be understood as distinct yet complementary. Transnational constitutionalism explains the global circulation of constitutional norms, while comparative public law provides the methodological discipline necessary to integrate those norms democratically. When applied carefully, transnational constitutionalism engagement strengthen democratic reliances, constrain executive power, and enhance right protection without undermining constitutional sovereignty. Thank you, sir.
All right, participant. I have no question for you.
Okay, sir.
Yeah. We can move ahead with the next participant.
Okay, sir. Our next presenter is Vikash Kumar Das from Gujarat National Law University, Gandhinagar. Participant, you may now proceed with the presentation.
Very good evening. Am I audible properly?
Yes, participant, you're audible.
Is my PPT is visible?
Yes, participant, it's visible. Please proceed.
Yeah. So very good evening to dear panelists and my dear participants. My name is Vikas Kumar Das, and today I'm going to present on the theme changing horizons in fundamental rights enforcement, reassessing the justiciability of fundamental rights against the private actors in digital age. So at the outset, I would like to begin with simple but strong constitutional basis that traditionally the fundamental rights were designed to operate primarily in vertical relationship, meaning fundamental rights were enforceable against the state, but they were not enforceable against the private actors or the large corporations or whatever. So, in the digital, however, the in digital era, like marked with artificial intelligence and very advanced technologies, the risk of fundamental rights being violated has been extended and expanded more way than we expect. So the notions that fundamental rights were traditionally enforceable against the state has no longer seems to be very adequate. Thereby, in today's world, if we see the most of the threats that arises is not directly from the state action, although there are some consumption that arises from state action, but the notion which has been shifting in nowadays, like the rights violation of fundamental rights, the basic fundamental rights has been shifted from state to private corporation, digital powered, digital large digital corporations and powerful digital platforms such as social media platforms, search engines, data brokers, AI driven system making, like companies which uses this AI automated decision making systems. So these did somewhat affect the fundamental rights of people too. Now let's in the era marked by digital constitutionalism, so the challenges that has brought forward with the advancement of technology, my paper highlights two complementary constitutional framework. The first is digital constitutionalism, and second one is transformative constitutionalism. Now, though, if we talk about digital constitutionalism, the digital constitutionalism is a concept which is very emerging in today's world. It basically tries to ensure that the core fundamental rights and the core constitutional values, which are which are privacy, liberty, equality, dignity, do not just go fade. It actually it must be incorporated in the digital space. So the these principles should govern as the enforceable principles of governance in digital space. And therefore, the digital constitutionalism argues that the core personal principles of constitutional values should be incorporated in the digital world to cover and protect the fundamental rights of people, which may be violated by the digital powers and large private corporations. So my paper argues that a state-centric model of right enforcement is insufficient in the era where private platforms increasingly shapes the human behavior, which controls the information, influences the democratic participation, and collect and processes large data, which is uh, which is non-public data, and that is being used for commercial purposes and exploitations of data. So, in such era marked by artificial intelligence and privatization of large public functions, the fundamental rights such as privacy, free speech, dignity are increasingly threatened by the powerful entities, and that raises the serious concerns of accountability and the rights protection. If such entities are permitted to evade from the constitutional scrutiny on the ground of being non-state actors, it would deem to be grant them a power of unchecked power to undermine the fundamental rights of people. So therefore, there must be a constitutional mechanism that curbs out their unrestricted power in this digital era, because the digital era is very vast. It is not something which a simple law rule can govern it in a very stringent manner. Therefore, the concept of digital constitutionalism and transformative constitutionalism marks a significant step, and it tries to adopt the constitutional values in the digital space by way of creating a mechanism that a constitutional values can be extended to the part to the
Participant, come to
small.
the conclusion. Come to the conclusion.
Okay, sir. So in India, we have seen that the judiciary has tried to incorporate, try to expand fundamental rights through the expansive interpretation of Article 21, from Maneka Gandhi to the latest judgment of M.K. Ranjit Singh, where in which judgment the Supreme Court recognized right to be free from the adverse effect of climate change. So, adverse effect of climate change is one of the core fundamental rights, which shows that how transformative constitutionalism is being adopted by the judiciary itself. And the later, at the most recent judgment, which is the Kausal Kishore versus State of Uttar Pradesh, which marks a significant doctrinal shift. It says that the fundamental rights enshrined in Article 19 and 21 can be enforced even against the private actors. So it is a significant ruling bit which which is very progressive, and which intends to protect the rights of people which may be affected by the private individuals, or private citizens or large corporations, or especially by digital powers. So that's how my paper tried to incorporate how constitutional rights can be extended towards the digitalization of the worlds, and how constitutional values can safeguard the rights of people that may be affected by the large digital powers such as Facebook or Instagram or digital platforms, whatever, and large corporations that exploits its data for their commercial purposes. So the core idea was, can the constitutional mechanism be extended towards the protection of people from the third party actors, which are not the state.
All right, participant. I
So that's
don't have
all from my end, and I thank you so much.
Yes, I don't have any such question for you, but there are few suggestions. Try to incorporate the jurisprudential aspects of rights of the fundamental right in your paper. So you had mentioned in various times that like this was supposed to be within the constitutional framework, but what is
Mhm.
the jurisprudential aspect of those framework need to be mentioned in a proper thematic way as per the like take some jurors views also, some of the ideologies of those jurists in order to map your paper with a better recommendations.
Thank you for the suggestion. Just to add one thing, so while I was going through my paper, my research, so the concept of digital constitution is very nascent. It has not developed that much yet. So I was trying
Look,
to
look for the
understand what.
literature. Look for the literature from Professor Upendra Bakshi.
Sure,
Professor
sir.
Upendra Bakshi, look for the literature. He had provided a concept of 3 C's of the living constitution.
Right,
So
right.
try to offer that. Yeah.
I'll surely incorporate it. Thank you for your suggestion. Thank you so much.
Yes. Yeah.
May I leave?
Thank you, participant. No further presentations, sir. No further participants. Uh,
Wait.
we
Yeah,
since
we can move to the concluding remarks. Yes.
Okay, sir. Okay. We sincerely appreciate the efforts of all the presenters and discussants and participants. Their research contributions have greatly enriched today's deliberations and strengthened the academic value of this conference. As we conclude technical session 2, I take this opportunity to express my heartfelt gratitude to our respected session chair, all presenters and participants, our collaborating institutions, and the organizing and technical team. Your support and cooperation have made this session successful. On behalf of CDIPR and the organizing committee, I thank you all for your valuable presence and active engagement. We look forward to your continued participation in the upcoming sessions of this conference. Wishing you all a very enriching academic experience. Thank you and have a wonderful day ahead.
Okay. Thank you, host.
Thank you, sir. Thank you.